Good evening. I'd like to start the meeting. Would you... All set? Okay, I'd like to start the meeting, if I could, please. Would you please join me in the Pledge of Allegiance? Could I have a roll call, please?
Present. Councilor Langevin?
Present.
Councilor Livingood?
Present.
Councilor Marcucci?
Excused.
Councilor McDonald?
I haven't heard anything.
Councilor Nicola?
Is he excused? Councilor McDonald will be excused.
Excused. Councilor Nicola?
Present.
Councilor Regis?
Present.
Councilor Spinelli?
Present.
Councilor Vandal? Present. 7 here, 2 excused.
Thank you. Agenda item number 3, Chairwoman's announcements. I have none. Agenda item number 4, Town Manager's announcements. Mr. Clark?
Actually, I have none either this evening.
Thank you. Agenda item number 5, Citizens Forum. Are there any citizens who wish to come forward this time?
Jim Satilli, Pinedale Street. A few weeks ago, I came up here and I asked this council what they've done since the election last June to improve the life of the citizens of Southbridge. And I noticed the Friendly's is closed. The National Guard moved out. And it's questionable whether the sports store is open or not. This is all downtown. So my question continues. What has this council done to improve the quality of life for the citizens of Southbridge?
I'd like to partially answer that by stating that, first of all, if you had stayed instead of left after you asked the question, Councilor Clements went through a whole litany of businesses that are new that have come into the community. I don't have that with me. I'm sure that if you pull up the meeting minutes, you'll see the list, and it's extensive.
I did. And
Well, that's good.
2 of those places closed. So
Which ones?
the Friendly's closed.
That wasn't a
And,
new business. She was talking about new businesses, Mr.
I get,
Sotilli.
okay. So if Southbridge goes dark, business-wise, whether it's old or new, there is a distinction?
Well, your question was, what has this council done? And she discussed new businesses that have come into the community since this new council has convened. That was your question. It appears that she answered that.
And that's the answer to my question?
Yes.
Thank you.
You're welcome. Do we have any other citizens wishing to come forward?
I wasn't going to come up during this segment, but after listening to the exchange
Please state
with
your
John
name.
Pulaski, after hearing the exchange with Mr. Satilli, you know, the rooster in the morning when he crows thinks he brought the sun up. I've been in business, and I've been on the Cape Cod Regional Transit Authority, Quinsigamond Community College Board of Trustees. If businesses come to town, it doesn't mean you folks did it. It means businesses came to town. And also, if a business leaves, it does not necessarily mean it's your fault. And it annoys me. Presidential campaigns, governors, gubernatorial campaigns. We blame governors and presidents for business, when truly the business cycles are different than the political cycles. So I just...
Just to clarify a little bit, I agree with you, but that wasn't the question, Mr. Pulaski. He specifically asked in his question about new business. And again, Councilor Clements answered the question.
Well, I know businesses that don't come to town because of things we have here, and that's what disturbs me. But
certainly,
and that is something
I
the council
agree.
can do.
I agree.
That is something the council could do.
Thank you.
Give us cleaner air and water so people want to be here. Thank you.
Thank you. Anyone else wish to come forward?
Good evening, Town Council. Stephanie DiMartino, 92 Harrington Street. Next Tuesday, October 25th, The Southbridge Tornado Relief will hold its next support group for the residents of Southbridge who were affected by the June 1st tornado from 7 to 8 p.m. at the Southbridge Community Center, 153 Chestnut Street. We'll also have a speaker that evening. His name is Mr. Ian Bubo, and he's coming on behalf of the utility companies, and he's bringing information for homeowners and business owners for financial resources and grants for rebuilding after the tornado. We'll also have 2 counselors on hand from the Mass Support Network, and I just want to say that the Southbridge Community Center and Mr. Trombley have been very kind and welcoming in letting us hold our support group there, and I'd like to thank them for that. Also, I have t-shirts still for sale. My phone number, because I always forget to say it when I come up here, is 508-909-5098. The t-shirts are $20 each. The proceeds are going directly to the families in the form of Walmart gift cards in the amount of $25 each. And so I ask that the town of Southbridge still please continue to support the families that have been affected by the tornado. I will have the t-shirts with me next Tuesday, or you can call me at home, and I'd be more than willing to meet with you. And I just would like to thank the town council and the town of Southbridge for all the support you have given us and the families. And that's it. Thank you very much.
Thank you. Would you like to add something?
Stephanie, have you posted this on the community, on the cable access? Your information about your meetings?
No, but
yeah, you can just, if you send something in, I'm sure we can get it up to Bob to get on for you. That'd be really good.
I did. Thank you.
Thank you.
Thank you. Anybody else wish to come forward? Okay, I'm going to move on to agenda item number 6, Councilors Forum. Councilor Livingood.
Thank you, Madam Chair. Just one question. If I have a white bag in my trash this week, am I going to get in trouble? That's a serious question because we've already filled one. I don't want to dump it out and put it in another bag.
Just a comment.
Just to let other people know.
We are enforcing the bylaw. The bylaw does call for a clear bag to be used. And the purpose of that is so that we can see if there's any inappropriate materials in there. We are also in the process of trying to put together an enforcement program for this. The primary elements of our enforcement program will be to make sure that people have no more bags on the street, but bags in the barrel. So we think we're going to have our hands full accomplishing that. That will be the primary focus of our enforcement efforts.
Okay, because I've had a lot of questions, and we already had one filled. I have clear bags now, but I don't, I really don't relish the thought of dumping from one to another.
If you put it in the trash barrel, you should be good.
It's always in the trash barrel. Thank you, Madam Chair. That's it.
Okay. Thank you, Councilor. Councilor Spinelli?
Nothing this evening.
Thank you, Councilor. Councilor Langevin?
Thank you, Madam Chair. Nothing this evening.
Thank you, Councilor. Councilor Vandal?
I'm all set this evening myself, thank you.
Thank you, Councilor. Councilor Regis?
Ditto.
Okay.
Thank you.
Councilor Clements? Anything?
I'm good, thank you.
Okay. Moving on, agenda item number 7, vote to enter into executive session pursuant to Mass General Law, Chapter 30A, Section 21A1, to discuss complaints or charges brought against a public officer and to return to open session to report results or to vote. And this comes with a bit of a, the individual caveat here is the individual reserves the right to discuss this matter in open session.
So moved.
Second.
Thank you.
Evening, Madam Chairman. For the record, my name is Gary Brackett. I'm an attorney with Brackett & Lucas, 19 Cedar Street in Worcester, and I represent Ann Fenwick-Bynum in the matter this evening. On behalf of Ms. Fenwick-Bynum, we'd like to request pursuant to Chapter 30A, Section 21A1, that this matter be conducted in an open public session, as is our right. And, Madam Chairman, before we commence the proceeding, I would like to raise a procedural question with you with respect to the scope of this meeting. Your council agenda makes it clear that this is a vote to discuss complaints or charges brought against a public officer, and the statute encompasses additional grounds for executive session which have not been included in the statutory notice to Ms. Fenwick-Bynum and are not on your agenda. Specifically, Chapter 30A, Section 21A1 says that to discuss the discipline or dismissal of or complaints or charges brought against a public officer. The notice presented by Mr. Caprara to me and to my client and your agenda item only talks about hearing complaints or charges. The notice does not contain any reference to the statutory language to consider the discipline or dismissal of Ms. Fenwick-Bynum. And so therefore, at the very beginning, I want to raise an issue with you that on the basis of the notice you have provided to me and my client, this hearing cannot consider discipline or dismissal of Ms. Bynum, no matter what form it may be represented as taking, rescinding a vote or something of that sort. The only notice you provided under the statute, and I'm sure, Madam Chairman, you and the members of the council know that this statute has been amended recently by the legislature to address and tighten up procedural issues and substantive issues. So the only issue that can be addressed by the council tonight is complaints and charges. And I would defer to you and through you, Madam Chair, to the town attorney so that we can reach agreement at least as to the ground rules for tonight's hearing, because I wanted to raise that issue now at the very beginning of this process. Thank you.
Thank you. Count.
Madam Chair, the notice is sufficient. It incorporates the language of the exception. It doesn't incorporate all the words, but the first exception incorporates several different scenarios. So the scenario that applies, those words are straight out of the statute. I believe ellipses have been used to indicate that it's not a full quotation, and that was the letter that I gave to you down in the parking lot a couple weeks ago. So you have notice what this is about.
So, Madam Chairman, if I can, just for the benefit of the members of the council, my client, and the members of the public, if Mr. Caprara can point to me either in his notice of October 6th or in the letter from Manager Clark of October 13th, where it specifically uses the terms consider the discipline or dismissal of an individual, because I will suggest to you, I've read the letter several times. Mr. Caprara says at this meeting the town council will enter executive session to discuss complaints or charges brought against a public officer. End of reference. So in the absence of any reference to discipline or dismissal, Madam Chairman, through you, do I understand Mr. Caprara suggesting that even though my client has not been provided with the statutory notice required by the statute, that this council will in fact be considering discipline or dismissal?
If I may. And we have had this discussion, but we can carry it forward in public. A motion will be made as a result. It would have been done in an executive session, but you're waiving that. So it will be made out here. And the motion will be made to confirm and acknowledge that the vote taken to confirm Mrs. Bynum to the Board of Health was invalid because of false pretense. It's not a removal. It's not discipline. It's a vote simply and singularly to determine if that vote on September 14th, 2009 was valid. So it's not for discipline, and so we didn't have to notice it. It's not for removal. We didn't have to notice it. It's a vote to determine, and I understand that this is different. It's a fairly simple concept that one can wrap their head around, but I know that there's a lot of people here who don't want to wrap their heart around it. They just refuse to wrap their heart around it. But the simple concept is, was the vote taken on September 14th, 2009 a valid vote? And that's the starting point, and that's the singular discussion point of the motion that's going to come forward. So we didn't have to notice up the other things.
Well, Madam Chairman, with all due respect through you to Mr. Caprara, I've been a public attorney for more than 30 years. I worked in a council manager form in the town of Watertown from 1981 to 85, the city of Worcester as city solicitor from 85 to 93. And I'm fairly familiar with the open meeting law and the requirements. These requirements predated the most recent changes to the statute. Later on in my presentation, I'm going to address an issue with respect to concerns that I presented to Mr. Clark in my letter of August 10th regarding some of the issues affecting Ms. Fenwick-Bynum. And I want to bring those to your attention in the spirit of fairness this evening, to try to make it clear to you what my concerns are with this entire proceeding. But let me come back to the specific question. This is the open meeting law under which this council is governed. It doesn't use the term rescind appointments. It doesn't use the term nullify or void ab initio, void as of the date of September 14th, 2009. It uses the terms for an executive session to discuss the discipline or dismissal of or complaints or charges brought against a public officer. And I will tell you that as a public attorney, I'm concerned that if this council proceeds, I have already filed one open meeting law complaint against the council, which I filed as a result of your meeting on September 12th, which I'll address later in my presentation. If the council proceeds to consider the removal of my client from a position she's held since September 14th, 2009, and you're going to do it on the basis of a notice that makes no reference to removal, then I would suggest, Madam Chairman, with all due respect, on behalf of my client, that you're exceeding your authority as dictated by the general laws of Massachusetts. And by exceeding your authority, it represents an issue with respect to personal exposure of members of this council to a civil rights violation. And I will provide you with the documentation in support of a 1989 decision involving the town of Hull and the Hull Redevelopment Authority, which resulted in just that kind of decision. Removal of an individual in violation of his or her procedural due process. The reason I bring it up at the very beginning is that I'm not attempting to lie in wait and bring this up later in litigation. I want to make sure that tonight we have a fair and open discussion of the issues and hopefully come to some resolution. But if the council is going to consider discipline or dismissal tonight, I'm telling you right up front, for the record, in an open public meeting, that I think you're violating the open meeting law and depriving my client of her rights.
Thank you. Do you wish to address any more of this?
If I may, Madam Chair, we are in an uncommon situation. How many of you know a person who's ever been on both sides of a lawsuit? It is as if one would have privilege in the huddles on both sides of the line of scrimmage. It's an uncommon and bizarre situation. And to be in conflict of interest and try to deal with it is not a situation that I trust many other towns have encountered. And so with the rules that we have, we are trying to navigate this matter to some resolution, publicly, openly. Documents have been given to you, better measurable by the pound than the page. You're aware why we're here. There are people here who are aware why we're here. But this is not a common situation. And just because it's not a common situation doesn't mean it can't be dealt with. And it's being dealt with in our town in an open way, and I would suggest to the council that we ought to proceed.
Thank you. We have a motion on the table with a second that I will entertain rescinding, seeing as we are not going into executive session.
I'll rescind that.
I'll take mine, yep.
Take your
Yep.
Okay. Can I have a vote on that, please?
Councilor Langevin?
Yes.
Councilor Livingood?
Yes.
Councilor Nicola?
Yes.
Councilor Regis?
Yes.
Councilor Spinelli?
Yes.
Councilor Vandal?
Yes.
Councilor Clements?
Yes.
7 yes.
Thank you. At this time, I think it's prudent that we have you speak first. Make the motion to have we're going to not be going into executive session, so we will make the it's going to simply be making the motion as, how do you wish it phrased, Mr. Caprera? I'd like to make a motion to vote to enter into Okay, I'm making a motion to acknowledge and confirm that Attorney Gary S. Brackett's client's appointment to the Board of Health by the Town Council at its regularly held meeting on September 14th, 2009, was obtained by false pretense, and therefore it was and is invalid. That's the motion, the vote. The motion.
So moved.
Second.
Now I'd like to open it up to discussion. And I'd like to start with Attorney Caprara, please. That's yours. Thank you. This is yours.
Robert Caprara, attorney for the town. Madam Chair and councilors, fellow citizens, as you've asked me to try to present this in the clearest, most concise way possible and to keep it simple, I will go through approximately 10 documents that are culled out of a pile of documents that are representative of two communications I've had with Attorney Brackett in the last 2 weeks. One is a letter with attachments dated October 6, 2011. I gave this to Attorney Brackett in the parking lot on that afternoon. I will leave these documents with the clerk and they will become part of our record. Secondarily, I have copies of a couple trailer documents that I came onto after giving Attorney Brackett this October 6th packet. I have faxed these documents to him, and he has acknowledged receipt of them. I believe you have a packet of documents, is that correct? And I am going to now give you these additional documents to add to it, so you'll have everything that Attorney Brackett has, everything that would be... Thank you. And I will give these to you so that you'll have them as well. And I'll let those circulate around before I start. And thank you for encouraging me to speak up. It's always difficult for me in this room. I know when I come in here, I don't hear that much. So if any time in my presentation I start to fade off, please, please bring that to my attention. All right, let me proceed. There is a motion before the Assembly, and it is to acknowledge and confirm that the vote taken by the Council relative to the confirmation of Ann Bynum on September 14th, 2009 is invalid because it was obtained by false pretense. That's a lot of words, and it requires some unpacking. And before I present information regarding that motion, what I would like to do is tell you really what that motion isn't. As I have been encouraged and admonished to try to keep this as simple as possible, these words would be guidelines for all of us to keep it as simple as possible, because it's reducing and closing in the scope of this analysis. The first thing that this motion doesn't ask to do is to remove a person from a quasi-judicial board. It's not asking to do that. So that comments, now effectively, and I hear the snickers, effectively that's what might happen. But what the motion is asking to do is not that. Secondarily, the motion is not asking to rescind the vote of September 14, 2009 and the parliamentary procedural problems that would entail. This motion simply is looking at the vote of September 14th, 2009 and determining if it was validly conducted. Let me give you two examples of this kind of situation, because it's not common. It's not hard to wrap your head around, but we just don't encounter it. So let me give you two examples. The first would be of a student who in high school cheats on numerous tests and beefs up their grade point and gets admitted into the National Honor Society. And 7 months thereafter is found out that he or she cheated on the tests and doesn't qualify for the National Honor Society. What do you do? What is done? Do you remove the person? Do you regrade the tests? Or do you simply acknowledge that the person did not qualify, did not meet the condition of being able to be on the National Honor Society? The second example is actually more fun and a whole lot closer to home. On January 21st, 1913, in the Columbia Hotel, Charles Clancy, baseball coach from eastern North Carolina, was vacationing up here, and he was talking with people, and he was overheard by reporter Roy Johnson. And what he overheard was that Mr. Clancy was the baseball coach for Jim Thorpe in the summer leagues in 1909 and 1910, where Jim Thorpe, then an athlete for Carlisle University, played baseball for $2 a game. And it made Jim Thorpe a professional. And Little Southbridge was significant because when Roy Johnson broke that story on January 22nd, 1913, that Jim Thorpe, the greatest athlete of the first half of the 20th century, was a professional, it cost Jim Thorpe his gold medal for the pentathlon and the decathlon at the Stockholm Olympics in 1912. Why did he lose the medals? Was it because of misconduct after he got the medals? No. Did he lose the medal because someone went back and looked at the ticker tape photographs to see if he in fact won or not won the race? No. He lost the medals because it was determined as a professional that he couldn't qualify to be an Olympian. It was determined he did not meet a precondition to be an Olympian. But it was determined well after the fact. He still lost the medals. Those symbols of his participation in the Olympics were removed from him. There is some occasions when it is important to look at the time that there's a vote or the time that there's activity to see if the person qualifies. And that's what this vote does. So what I'd like to do is go through some information that is all public records regarding the vote of September 14th, 2009. It may be cumbersome to indicate to you, look at this in your packet. There is so much information that would take time. Let me just go through this as cleanly as I can. These are the operative facts. The first would be that on July 8th, 2008, a complaint was filed in the Worcester Superior Court in which Ian Fenwick Bynum was a party plaintiff. One of the defendants was the Southbridge Board of Health. Another document that's found in the packet is the docket sheet from the Worcester Superior Court for that same case, which reflects that a motion was filed on April 16th, 2010 for Ian Bynum to be removed from that lawsuit, and the motion was allowed on April 28th, 2010. And so what we have is a situation that the vote took place to put her on the Town Board of Health on September 14th, 2009, and roughly 7.5 months later, she was removed from the lawsuit. Or in other words, for those months, she was in conflict of interest. I might add, in that motion that was filed on April 16th, the grounds that the attorney used for her to be removed from the lawsuit was in the second line where it said, as a result, a conflict of interest has arisen, and I thought that was a very interesting admission why the judge should allow her out of the case at the time, 7.5 months later. Shortly before July 2nd, 2009, Town Manager Chris Clark made a decision pursuant to his authority under the charter to make appointments to the Board of Health. He prepared a memo and he gave it to the Town Council. It's dated July 2nd, 2009, and it reads as follows. The town has 2 persons on the Board of Health, one of whom is Ronaldo Bernardone, who has expressed interest in being reappointed to the board, and with the election results for Town Council, Mr. Bernardone has expressed strong interest in remaining on the Board of Health. Therefore, I recommend Ronaldo Bernardone to another 3-year term as a reappointment. Ms. Judith Zato has submitted a letter indicating a desire to not be reappointed, which has promulgated us to advertise for the position. We advertised on the local cable TV and the town website. We have received 2 inquiries, one from Ms. Ann Fenwick-Bynum and the other from Mr. Robert Chakosky. I have interviewed both candidates and believe both candidates to be well-deserving of the position. However, I put forth Ms. Ann Fenwick-Bynum's name as my appointment to the Board of Health because of her skills, i.e. nurse working with Harrington Memorial Hospital, HMH. Match the departing member's qualifications. If an additional vacancy occurs, I will recommend Mr. Chakosky for any future appointment. Should you have any questions or concerns regarding the above, please do not hesitate to contact me. That was a memo issued on July 2nd. On July 2nd, 2009, Town Manager Clark also sent a letter to Ms. Ann Fenwick-Bynum and wrote, Dear Ms. Bynum, thank you for taking the time to meet with me yesterday to discuss your interest in serving on the Board of Health. I'm assuming from this that she met with Mr. Clark the day before. It is my intent to bring your name before Town Council for confirmation to fill the open position on the Board of Health. I do have a concern that I feel needs to be addressed prior to the appointment. I'm asking that you contact the State Ethics Commission to request a determination that your participation in the lawsuit filed against the town of Southbridge Board of Health, and has parenthesis, copy of cover page enclosed, I don't have that with it, will not present a conflict of interest. Once you have received a determination from the Ethics Commission, please let me know so that I may proceed with the appointment process. Should you have any questions, please do not hesitate to contact me. What I would highlight on this page is the last line of the second paragraph. Once you have received a determination from the Ethics Commission, please let me know so that I may proceed with the appointment process. That is to say, the appointment process and the completion of the appointment process was conditioned specifically on getting that report. Based on a letter from attorney Lauren Duca, who is the senior staff counsel of the State Ethics Commission, I will suggest, based on this letter, that Mrs. Bynum emailed a correspondence, a communication to attorney Duca dated July 8, 2009. And I say that because attorney Duca references to that July 8, 2009 email. It is apparent that after Mrs. Bynum was asked by the town manager to get a State Ethics Commission determination, she did in fact do that. And on July 20th, that determination was issued by attorney Duca. It's in the packets, 4 pages long. I will not read the whole thing, but I'll read the first part of it. It says, Dear Ms. Fenwick-Bynum, I am writing in response to your recent request for advice under the Conflict of Interest Law, General Law, Chapter 268, capital A. You are seeking appointment to the Board of Health in the town of Southbridge. You state that you have formally removed yourself from a lawsuit against the town and its Board of Health involving the expansion of a landfill based on the allegation that there was never a proper site assignment. You further state that you will no longer participate in any further meetings or discussions with the attorney representing the plaintiffs in the lawsuit or any landfill issue/site assignment issues. You have asked whether you may be appointed to the Board of Health in light of your prior participation in the lawsuit. This opinion, this is Attorney Duca writing, this opinion is based on my understanding of the facts from your email request for advice dated July 8, 2009, which are incorporated herein by reference. Based on the information you have provided, I can give you the following advice, and the opinion goes further on. But I would note that as she writes and says, based on the following information you provided, she's noted footnote 1. And if you read down to the bottom part of the page, footnote 1 says in part, begins, in providing this opinion, we have relied upon the facts as you have stated them and have not made any independent investigation of those facts. I will proceed with the fair belief that Attorney Duca is relaying the information she was given, and as Attorney Duca writes in the third line, you, referencing Mrs. Bynum, you state that you have formally removed yourself from a lawsuit against the town and its Board of Health involving the expansion of a landfill based on the allegation that there was never a proper site assignment. Based on getting that letter report from the Ethics Commission, it goes on and states that there are some restrictions that she would have to abide by if she were to go forward. Town Manager Clark moved the appointment process forward, and it wound up before the Education and Human Services Subcommittee on Thursday, August 6, 2009, and I'm referring to the minutes of that meeting. Present at that meeting were Chairwoman Clements, Councilwoman Regip, Councilor Livingood, Councilwoman Nicola, Town Manager Clark, and Mrs. Bynum, among numerous others. Agenda item number 3 at that meeting is entitled New Appointment to Board of Health, and the minutes read, Mr. Clark gave an overview of the appointment needed and the interest expressed. 2 candidates were interviewed. Mr. Clark made a recommendation that Ann Fenwick Bynum be appointed to the Board of Health. After discussion, it was requested that Mrs. Fenwick Bynum submit a letter from the attorney that she is not a party to the lawsuit against the town, and a letter from the Ethics Commission with clarification of Section 23B3. A motion was made by Councilor Livingood and seconded by Councilwoman Regis to postpone appointment until the needed paperwork is submitted. Vote by a show of hands, 3-1, McDonald abstaining. So at that time, and this is Larry McDonald Sr., he was there as well. At that time, as the minutes reflect, Mrs. Bynum was told specifically that the appointment process would not move forward unless she submitted 2 things. Number 1, a letter from the attorney that states she is not a party to the lawsuit against the town, and number 2, a letter from the Ethics Commission with clarification of Section 23B3. 23B3 is the conflict of interest provision. Those were the conditions of her appointment moving forward in the process. After the meeting of the EHS subcommittee on August 6, 2009, the subcommittee, Education and Human Services Subcommittee, reconvened on Wednesday, September 2, 2009, and I'm referencing to the minutes of that meeting. In attendance were Chairwoman Clemens, Councilwoman Regip, Councilor Livingood, Councilor Lazo, Councilor Vecchia, Councilwoman Nicola, Councilor Vandal, Town Manager Clark, Ian Bynum, and several others. Agenda item number 1 at that meeting is entitled Review Appointment of Ann Fenwick Bynum to the Board of Health. It continues to read, Mr. Clark stated that the information requested from Mrs. Fenwick Bynum had been received. A motion was made by Councilwoman Regis and seconded by George Parent to appoint Ann Fenwick Bynum to the Board of Health. Vote by a show of hands, 7-0. So based on that vote and based on the information that those two matters had been attended to, the vote went forward 7-0, which meant it now moves out of subcommittee to go to the full town council. That was dated, that was the meeting of September 2nd, 2009. In follow-up of that meeting, a letter was sent from Mr. Clark to Mrs. Bynum dated September 3rd, 2009. Ray, intent to withdraw case against the town of Southbridge and the Board of Health, Superior Court Department of the Trial Court, Worcester Division, Civil Action Number 08-1532B. Dear Mrs. Bynum, please provide to my office the court documents when finalized by the court that both you and your husband, Larry Bynum, have withdrawn from the lawsuit against the town and the Board of Health involving the expansion of the landfill, Superior Court Department of the Trial Court, Worcester Division, Civil Action Number 08-1532B. Once the material is received, we will move forward to allow your appointment to the Board of Health for a 3-year term to expire June 30, 2012. Your attention in this matter would be greatly appreciated. Subsequent to that time, and I could stand to be corrected by the town manager, but it is my belief that a motion not signed was presented, a motion for dismissal or removal was presented to you, and then based on that, the matter was scheduled to go to the full town council at the meeting on September 14th, 2009. At that time, the councilors present were Councilor Clements, Councilor Lazo, Councilor Livingood, Councilor Logan, Councilor McDonald, the senior, Councilor Nicola, Councilor Regip, and Councilor Vandal. Councilor Vecchia was excused in that meeting. In that meeting, the minute notes at number 10 recite, vote to confirm the town manager's appointment of Ann Fenwick Bynum to the Board of Health for the town of Southbridge for a 3-year term to expire June 30, 2012. A motion was made by Councilor Vandal and seconded by Councilor McDonald. Vote by roll call. Those in favor, Clements, Lazo, Livingood, McDonald, Nicola, Regis, and Vandal. Excused, Vecchia. Motion passes. So the passing of that motion was 8-0. It is my understanding that the councilors had the ethics opinion and the motion unsigned in their packets when they were voting. As I mentioned at the first, on April 16th, 2010, a motion was finally presented to the Worcester Superior Court. It was dated April 15th, 2010, and it was approved by the judge. It was allowed, which would be the term for motion. It was allowed on April 20th, 2010. A copy of that motion's in the packet, and it's entitled Plaintiffs Ann Fenwick Bynum and Larry Bynum as assented to motion to withdraw from 10 Citizens Group. It's a short paragraph, and it reads, plaintiffs are comprised of 10 citizen groups listed in the party registration forms attached hereto as Exhibit A. Because a conflict of interest has arisen, Ann Fenwick Bynum and Larry Bynum no longer wish to participate in this appeal and are hereby withdrawing. Both have asserted in the affidavits attached hereto as Exhibit B that there were 11 members in each of their 10 citizen groups. The essence of the phrase, because a conflict of interest has arisen, actually needs to be understood that upon her swearing into the Board of Health, the conflict of interest existed, and it didn't just arise, and it took 7.5 months to address it. As part of the packet, and this would be just for the record, but as part of the packet that will go to the clerk and be part of the record for open meeting law purposes. On October 3rd of this year, I obtained 4 signed affidavits from Councilor Regis, Councilor Nicola, Councilor Clements, and Councilor Livingood. They were in attendance on September 14th, 2009, and voted in the affirmative for the confirmation of Ian Bynum to the Board of Health. These 4 affidavits have the same wording, so I will read it once. I will not read it 4 times, but this is essentially the affidavit. For Councilor Regis's affidavit, it reads, I, Pam Regis, under oath hereby depose and say that, number 1, I served as a town councilor for the town of Southbridge at the regularly held town council meeting on September 14th, 2009, when I cast an affirmative vote to confirm the town manager's appointment of Ann Fenwick Bynum to the Board of Health for the town of Southbridge for a 3-year term to expire June 30, 2012. Attached to this is that agenda item, the minutes of the meeting. Number 2, if at the time of the aforementioned vote on September 14, 2009, I was aware that Ann Fenwick Bynum had not yet removed herself from the lawsuit against the Town Board of Health, I would have not voted affirmatively for her confirmation to the Board of Health on September 14, 2009, signed under the penalty of perjury. That same affidavit is the language for Councilor Nicola, Councilor Clemens, and Councilor Livingood. I obtained a 5th affidavit from ex-Councilor Vecchia. He was excused that day, but he was willing to sign the affidavit. His says a little bit differently. I, Albert Vecchia, under oath hereby depose and say that I served as a town council for the town of Southbridge in September 2009. However, I was absent and excused from the town council's regularly held meeting on September 14, 2009, when a vote was held to confirm the town manager's appointment of Ann Fenwick Bynum to the Board of Health for the town of Southbridge for a 3-year term to expire June 30, 2012. And then number 2, if at the time of the aforementioned vote on September 14, 2009, I was present at the town council meeting, and if I was aware that Ann Fenwick Bynum had not yet removed herself from the lawsuit against the Town Board of Health, I would not have voted affirmatively for her confirmation to the Board of Health on September 14, 2009. In essence, these affidavits are part of the record simply to confirm that if information had been accurately conveyed to the councilors, the vote would not have passed. There were 8 voting. It had to have 5 in favor. The 4 who voted said they would not vote. At the best, it would have been a 4-4 vote. It would not have carried. These affidavits will become part of the record. Also, as part of the record, and I don't really want to go this far, but just so it's acknowledged, under Chapter 268A, Section 23B3, a person, a public officer, can remove the stigma of conflict of interest in a matter if they disclose it with a form filed to their appointing officer. I have attached affidavits in this packet from Town Manager Chris Clark and from Madeline Dowse, the Town Clerk, affirming that they have never received the filings of this 23B3 disclosure statement. Madam Chairperson, I would stop now. I could keep going, but I think that would be it.
Thank you. Does anybody have anything up here that they wish to add? Attorney Brackett?
I may just have a moment, Madam Chair, please.
Certainly.
Once again, Madam Chairman, members of the Council, on behalf of Ms. Fenwick-Bynum, I'm here to respond to the presentation made by Mr. Caprara. And one of the things I'd like to draw your attention to is, which Mr. Caprara didn't refer to in his comments, is a complaint from Tom O'Leary, the Chair of the Board of Health, which, as I understand it from reading the notice, is the basis on which this meeting is being held. So you have not yet heard any presentation regarding what the concerns were of Mr. O'Leary. Because I guess the question is, if he's the one making the complaint, although I did speak to Mr. Caprara, and he's not here tonight. Mr. Caprara told me he wasn't planning on being here. He's not available for me to ask questions. He's not available for you to ask questions. So all we have to go on is his letter. Now, the first thing I point out to you is the letter was directed to Mr. Clark, the town manager, and it's dated May 20th, 2011, received on May 26th, 2011. So the first question I would suggest that you should consider as part of this proceeding is, why are we here on October 19th regarding a complaint that was received by the manager on May 26th? The other issue I'll ask you to consider is Ms. Fenwick-Bynum was formally removed from the lawsuit as of a court order entered April 30th, 2010. This is a year and a half later. So we have a complaint that's 5 months old, and we have an issue which apparently predates the fact that she followed through and secured removal from the lawsuit a year and a half ago. So I ask you to consider that as a first issue for any of you, no matter where you work, public or private sector, the first issue any of you would consider in reviewing a question of action against an employee or an officer is the timeliness of the issue being brought to your attention. In this case, you're essentially serving as counsel. You are the appointing authority, subject by virtue of your confirmation of this appointment. So let me raise another procedural issue before you. What you don't have before you tonight is a request by Mr. Clark to remove someone that Mr. Clark originally recommended that you confirm. So we have a complaint that's 5 months old, satisfaction of a condition that's 18 months old, and you're being asked to take action as the counsel. One of the questions I'll ask you to consider when I give you a handout in a few moments is, what's the source of your authority to take this action? As a public attorney, the first thing I learned many years ago when I began practice is you have to find a source of authority for a public official to take an action that affects either an officer or employee or a member of the public. Otherwise, the public official is acting without authority, or the Latin term ultra vires, without authority or in excess of authority. So I ask you to consider the timeliness, and I also ask you to consider the merits of the complaint, because you're being told this is not a removal proceeding. And on behalf of my client, I would suggest to you that it clearly is a removal proceeding. All you have to do is look at Mr. O'Leary's first question. With this letter, I'm requesting you begin the process of removing Ms. Ann Fenwick-Bynum from her position of the Board of Health. So Mr. Caprara may want to try to tell you this is void as of September 14th, 2009. Mr. O'Leary makes it very clear what he's asking Mr. Clark to do, sending the letter to Mr. Clark, because Mr. Clark is his appointing authority, subject to Mr. O'Leary being confirmed by you as the counsel. The letter goes on. You're aware that in order for her to be appointed to the Board of Health, Ms. Fenwick-Bynum had to submit to certain requirements. I'm hoping you have a copy of this Mr. Caprara has provided to you. Those requirements included her removal from the lawsuit, and I would agree. The requirement was she had to remove herself from the lawsuit. But Mr. O'Leary goes on to say, as well as her sworn statement that she would not engage in any activity involving the landfill or the site assignment, that through her vote or official action would be obstructive or detrimental to the board's ability to engage with the landfill operator in a constructive and progressive manner. And Madam Chairman and members of the council, next to my copy of this, I put a question mark, because the obvious issue is if he's representing that was a condition of her appointment, where did Ann Fenwick-Bynum ever make that commitment? Where did your council subcommittee ever make that a requirement? Where did Mr. Clark ever make that a requirement? Where did the council, when they confirmed the appointment on September 14th, 2009, make that a requirement? I would suggest to you, Mr. O'Leary is wrong. That was not a condition of Ms. Fenwick-Bynum's appointment. And I'll go through that with you in a few moments. He then goes on to say, it's obvious to me that shortly after her appointment to the board, Ms. Fenwick-Bynum's intentions, as evidenced by her voting record, and her actions have clearly demonstrated her specific intention of reversing the board's 2008 decision regarding the contract between the landfill operator and the town, as well as the site assignment pertaining to the same agreement. Mr. O'Leary has a concern with her voting record. I ask you to consider that when I give you the information regarding the Town of Hull case, and whether or not it's you as a member of the council or Ms. Fenwick-Bynum as a member of the Board of Health. Your right to vote is an expression of your First Amendment right of free speech, protected by the U.S. Constitution, the Mass Constitution, and most recently the case of the Hull Redevelopment Authority. So Mr. O'Leary doesn't like her voting record. He wants her removed. He's got it wrong as to what her obligations were when she took the office. That's our position. He then goes on to say that Ms. Bynum's actions put the town in jeopardy of litigation that could represent significant burden to the town's ability to negotiate with integrity. And more importantly, her actions act as a drain on the board's ability to focus on its most important duty, the preservation of our citizens' health, safety, and the preservation of our environment. Mr. O'Leary doesn't like the way Ms. Fenwick-Bynum votes. He thinks that this is somehow or other affecting the ability of the Board of Health to do its work. He's not saying anything about misrepresenting what took place before the council on September 14th, 2009. But somehow or other, this complaint, which is the basis of Mr. Caprara's letter to my client, he clearly references it in his letter to Ms. Fenwick-Bynum, the letter he gave to me outside this building on Friday, October 7th. This letter talks about actions that Ms. Fenwick-Bynum has taken since her appointment. So I ask you to read this very carefully because you're talking about a very important decision here. A decision regarding the removal of a member of the Board of Health on what I would allege to be a lack of authority. Now, if this is a complaint to charge, and I come back to the question of the reason for this executive session, these are the complaints or charges. Mr. Clark hasn't made any complaints or charges against Ms. Fenwick-Bynum. If they were presented, they would have had to be included in the notice so we could properly defend ourselves. And we have the same right any one of you would have in a similar circumstance. Procedural due process. We have the right to receive the charges, a right to appear, hear the witnesses against us, to present our own evidence, request a fair and impartial deliberation and decision by you as the council of the town of Southbridge. Mr. O'Leary's not here tonight, so I don't have the ability to ask through you, Madam Chair, the questions of him. Where did he get the citation to the allegation that Ms. Fenwick-Bynum made a sworn statement she would not engage in any activity? I would suggest to you if he's misreading the conflict of interest opinion, that may be the source of his problem, and I'll get to that in a moment. Madam Chairman, I've prepared this to try to assist in my presentation. I understand that your time is valuable. This is an important matter to my client. I want to try to be as efficient as possible in this matter. But I want to point out to you that these issues represent some what I believe to be very major issues with respect to Ms. Bynum's right to continue her service, this council's right to consider her removal. I start off at the very beginning with the first question, whether the town council acting on its own has the legal authority to rescind the appointment of Ann Fenwick Bynum to the Board of Health. Now, Mr. Caprera, in the motion that's been presented, is to acknowledge and confirm that the appointment was obtained by false premises and was invalid. He would suggest to you this is not a removal. I would simply say to you, listen to the evidence. My client's been serving in the position for more than 2 years, September 14th, 2009 to October 19th, 2011. This is not a removal. I'm sorry, this is a removal. This is not an action as framed by Mr. Caprera, because she has participated in a number of actions and votes on matters, whether they relate to the landfill or any other matters, code enforcement issues, state sanitary code issues. She's participated as a full-fledged member of the Board of Health during that entire time. To try to suggest that by Mr. Caprera's presentation that you can somehow or other wipe out those 2 years of service because of some alleged misrepresentation, I suggest to you, is without any source of authority. Mr. Caprera presented 2 examples in his opening remarks as to how he thought that somehow or other these proceedings were similar to the ones he presented to you. But what you didn't hear from him was a case in the Commonwealth of Massachusetts involving a removal by a town council of an official of the town in this fashion. Any one of us who are attorneys, when we go before a judge, we try to say, Your Honor, you should decide in my favor because I have the following 5 cases that all are similar to these facts. And if you apply the law to our case similar to those 5 cases, we should prevail. Mr. Caprera would come in with 5 other Massachusetts cases or federal cases and say, no, Your Honor, these cases say that the decision should go in my direction. With all due respect to Mr. Caprera, neither one of the examples he used has any reference to the code, the case law, or the statutory law of Massachusetts. So the starting point is, what is your authority? Now, your charter, which I would suggest, when I worked in Watertown, we changed from a town to a city form of government in 1981. The Southbridge charter was one of the charters that was reviewed by our charter commission. The first manager I worked for was Peter Boyer, who was the former town manager in Southbridge who came to Watertown in 1981. So you look at the charter says power to rescind appointments. Does the charter on numbered page 1 have any reference to the suggestion that Mr. Caprera has made? The answer is no. The power to rescind appointments begins with the town manager. The town manager shall have the power to rescind subject to confirmation by the town council for cause. The town manager hasn't presented a petition for rescission. He hasn't provided you with a statement of reasons. But even if he did, your charter as it currently stands contains section 442. Said power shall not apply to quasi-judicial bodies as determined by the town attorney. Now, it's my understanding that you've recently received a proposed amendment to the charter to delete that portion. Of course, that has to follow the procedure under 43B, has to go to the Attorney General's office, has to come back to the voters. So that's not in force and effect today. And so because it's not in force and in effect, this provision is still in force and effect. The amendment doesn't take place until the voters of Southbridge say, we adopted this charter some years ago. Yes, we agree we want to amend the charter in this fashion. They'll either tell you yes or no. But you can't act as though this section's been removed until the voters take that action. So my suggestion, Madam Chairman, was Mr. Clark isn't moving the removal of Ms. Fenwick Bynum. Even if he tried to, we would argue the charter prohibits it. And in the absence of a removal under Section 4, the question you have to ask yourself and ask Mr. Caprera is, what is the source of your authority in the charter, or the Southbridge bylaws, or the Mass General laws, or the case law of the Commonwealth of Massachusetts? There are 4 sources. I will suggest to you, having reviewed that information, and being familiar with matters of this sort. And I don't say that in a cocky fashion. I say that to you just because I've been involved in these matters in the past, and many nights I'm sitting on the same side of the table as Mr. Caprara, advising public officials. There is no authority to take this action. On numbered page 2 and 3, I've included a reference, as you'll see at the top, the Massachusetts Practice Series Municipal Law. This is a series that's available to attorneys to review. I wanted you to know that there's a reference there that I've checked about halfway down the page. The general rule is that the power to remove is incident to the power to appoint. And under your charter, Mr. Clark's ability to appoint subject to confirmation has a commensurate power to remove subject to action, except for quasi-judicial bodies such as the Board of Health. So the town of Southbridge has exercised its right in that area and drawn the line. We will allow Mr. Clark to petition removal of someone unless they're a member of a quasi-judicial body. Let me direct your attention to the next page. And I'll briefly mention this. And once again, I will preface my remarks by saying I am hoping that there's no litigation as a result of this evening's proceeding. On behalf of my client, I'd like to spare her the bother, the expense, the emotional toll that takes. But, footnote 5, town and members of its Board of Selectmen violated First Amendment rights and rights under the Mass Civil Rights Act of members of Redevelopment Authority when town and members of the Board of Selectmen used their powers to remove authority members for voting contrary to the wishes of the Board of Selectmen. 1989. You'll see that that's First Circuit. That's the First Circuit Court of Appeals of the U.S. court system. And you'll see certiorari denied. The U.S. Supreme Court denied review of that case, so they let it stand. So that's the law of the First Circuit as it stands. There are other cases that support the same principle. I point that out to you, Madam Chairman, because the question is, if my client has procedural due process and you don't have any authority to remove her, and Mr. Caprara is asking you to remove her, I will say, simply stated, he's exposing you to individual liability for civil rights actions. The second point on the first page I'd like to bring to your attention, Madam Chair, is whether this meeting tonight is the result of an illegal executive session of the Town Council held on September 12, 2011. It's my understanding, and Mr. Caprara can confirm, that on September 12th, I understood that the Council was going into executive session to consider the letter that I sent on August 10th. And let me suggest to you that under the open meeting law, the only way you can go into executive session for litigation is if there's a pending case today or it's imminent. If there's a potential litigation case, as opinions of the district attorneys of the Commonwealth of Massachusetts have rendered, potential litigation is not sufficient to allow for an executive session. It has to be imminent. You have to be threatened with litigation tomorrow. And let me just suggest, members of the Council, as you consider the issues I'm presenting, when I sent my letter on August 10th, if you look on page 5, the second page of my letter, I asked Mr. Clark in the first paragraph there to cease and desist from any and all efforts to seek Ms. Bynum's resignation. The last sentence, to do so would subject you to a suit for civil rights violations under the U.S. Constitution, the Mass Constitution, the Bill of Rights. I say to do so would subject you to a suit. I don't say I'm filing the suit on August 11th or August 12th. I'm advising Mr. Clark of the fact that he may be exposing himself. I then go on to say, I trust it will not be necessary to institute litigation to protect my client's rights to hold her position for the term of office to which he is appointed. I'm sad to say that I never received a response to this letter. This letter was sent on August 10th, today's October 19th. In the course of more than 2 months, I've never received a response to this letter. But we're here tonight. So from where I sit, Madam Chairman, the attempt that Mr. Clark made to force Ms. Bynum to resign in his office with the presence of the police chief has now manifested itself in this suggestion to you that you somehow have authority to remove her 2+ years into her appointment. So I ask you to consider the big picture here, that you're acting tonight, obviously as a result of information that was given to you on September 12th, for which I currently have an open meeting law violation pending before you, to which you have to file a response to the Attorney General's office and to me. And if the response doesn't acknowledge a violation, we proceed with that violation, which then raises a question as to whether or not any action taken tonight on the basis of what you heard on September 12th or any meeting between September 12th and tonight is tainted by virtue of the fact you were behind closed doors without notice to my client, to which she's entitled. If you heard complaints or charges against her in executive session when there was no pending or imminent litigation, you were violating the open meeting law. And if tonight is the third step, either the second or third step, one meeting and tonight or two meetings and tonight, then this is the end result of an illegal process. I'm telling you this up front because I have concerns. I sent the letter to Mr. Caprera on September 12th. I told him that day I thought that going into executive session was illegal, that there was no imminent litigation. If I said to you tonight I'm going into court tomorrow, that would be a basis for you to seek an executive session. You don't have notice. You're hearing it tonight. It may justify an executive session for imminent litigation. I've included a couple of pages of the open meeting law in addition, which I hope you'll take a look at, but I would like to refer you to some information contained therein. And specifically, if you look on pages 7 and 8, the bottom of page 7, paragraph 23, talks about enforcement of the open meeting law, complaints, civil action. The last sentence before subsection 1 says, upon the finding of a violation, the Attorney General may issue an order to, and if I can direct your attention to the next page, number 5, to reinstate an employee without loss of compensation, seniority, tenure, or other benefits. So the statute already anticipates the fact that someone's employment or status with the town may be affected by an illegal executive session. And if you've in fact had meetings behind closed doors where my client wasn't given notice and we didn't have a right to participate, and as a result of those meetings we're here tonight on a single item agenda, then the Attorney General would have the authority to reinstate my client to her position. But the question I guess I ask you is, after you listen to the other evidence, we may not even have to use the open meeting law to find that there's no basis to take her out of her office. Let me just follow, and I'll try to go through as quickly as I can, Madam Chairman, the correspondence, and not only the correspondence that Mr. Caprera referred to, but additional correspondence that was in this full packet of materials. These were the documents Mr. Caprera gave me as part of the notice, and I went through them and carefully culled out documents in addition to the ones he presented that I think are very important for you to consider. We've already referred to the July 2nd letter that's on numbered page 10. And once again, I just want to ask you to consider the requirements imposed on Ms. Fenwick-Bynum. Mr. Clark says in the middle of that second paragraph, I'm asking you contact the Ethics Commission to request a determination that your participation in the lawsuit filed against the Southbridge Board of Health will not present a conflict of interest. Once you've received a determination, please let me know. I'll proceed with the appointment process. Well, the only condition as of July 2nd is getting an opinion from the Ethics Commission. Let's move on to the Ethics Commission opinion, which is numbered pages 11, 12, and 13 of the package. And without going through it in its entirety, the Ethics Commission attorney addresses two areas under the Conflict of Interest statute. Section 19, which involves financial interest, Section 23, which involves standards of conduct. On the second page, numbered page 12, you'll see in the first full paragraph, as applied to you, while a Board of Health member, you may not participate in any particular matter in which you or any person or entity set forth in Section 19 has a financial interest. For example, you may not participate in matters involving the landfill, including the site assignment, if you, your parents, or siblings own abutting or nearby property. Well, the clear import of that is if Ms. Fenwick-Bynum and members of her immediate family don't have a financial interest, she's not prohibited from participating under Section 19. Let me direct your attention to the numbered page 13. The second category, standards of conduct, relates to the so-called appearance of a conflict of interest. If I can direct your attention to the top, the incomplete paragraph at the top, the first full sentence. Your prior private relationship with a lawsuit and individuals associated with it creates an impression of a conflict of interest or bias in your official actions. To dispel the appearance of conflict, 23B3 requires that prior to participating, you file a full written disclosure with your appointing authority. This written disclosure is a public record. So the Ethics Commission is suggesting that this is a way of allowing Ms. Fenwick-Bynum to go forward, participate in the Board of Health, as long as she has a disclosure. There's no financial interest. She's trying to dispel that she's unduly influenced by kinship rank or position of people regarding the landfill. So that's the Ethics Commission opinion. Once again, I suggest to you that if there are any questions regarding any of these documents as I go through, I'd be happy to answer them as we go along, because this is where I think Mr. O'Leary may be mistaken, because the representation in the first paragraph, you further state you will no longer participate in any further meetings or discussions with the attorney representing the plaintiffs in the lawsuit or any landfill issues, site assignment issues. The prohibition is against further meetings or discussions with the attorney. Now, if Mr. O'Leary is reading that to somehow or other include the fact that she's prohibited from any meetings, well, frankly, ladies and gentlemen of the council, that's news to my client, and it should be news to you, because Ms. Fenwick-Bynum was presented to you by Mr. Clark, and Ms. Fenwick-Bynum, as you'll see from the documents to be presented, was cleared for appointment by you, for you, by Mr. Clark. So I believe, with all due respect to Mr. O'Leary, he's misreading that paragraph. Ms. Fenwick-Bynum cannot meet with the attorney or discuss the lawsuit or any landfill issues, site assignment issues. But that doesn't say she can't participate as a member of the Board of Health on the landfill, because the opinion says she can participate as long as she doesn't have a financial interest, and she can participate as long as she files a disclosure statement. Because otherwise, the matter would be over at that point. So I ask you, Madam Chairman and members of the Council, that you have to read this carefully in light of the successive documents that I'll present to you.
Yes, Counsel. Counsel Regis.
Thank you, Madam Chair. Through you, if I may, to Attorney Brackett, I don't see a copy of that disclosure here.
No, it's not included in the file. It's our position that Ms. Bynum prepared and filed a written disclosure, but she's been unable to find a copy from the clerk's office. Apparently the clerk and Mr. Clark said they never received a copy.
And she didn't maintain a copy on a computer or anything?
She does not have a copy on the computer. She filled out a disclosure form under 23B3.
Right.
And it's an important question because it's one of the questions that I asked as I was going through the documents. And she's made a search, which raises the obvious question, if the disclosure wasn't filed after the conflict of interest opinion was presented, then we're taking the position it was filed because Mr. Clark moved forward with the appointment before the full council. If it hadn't been filed, then arguably it would have been reason to say, hold up on the appointment until the disclosure is filed. But our position is a disclosure was, in fact, filed, and apparently there's no record of the disclosure. And I think as I move on, through you, Madam Chair, as I move on to the other documents, I think you'll see where my argument that these documentation requirements were satisfied is actually attested to by Mr. Clark. Madam Chairman and members of the Council, if you look at the minutes of the Education and Human Services Subcommittee meeting, the subcommittee makes requirements in which they say, after discussion, it was requested Ms. Fenwick-Bynum must submit a letter from the attorney that she's not a party to the lawsuit against the town, and a letter from the Ethics Commission with clarification of Section 23B3. Those are your committee's, subcommittee's requirements. At the next meeting of the subcommittee, numbered page 15, the minutes of September 2nd, as is noted in Agenda Item 1, Mr. Clark stated the information requested from Ms. Fenwick-Bynum had been received. So we're assuming that as of September 2nd, since Mr. Clark is representing this to your subcommittee, that the letter from the attorney has been received and the ethics opinion has been received regarding 23B3, because that's specifically referenced. A letter from the Ethics Commission with clarification of Section 23B3. Otherwise, if there was still outstanding paperwork on September 2nd, why would Mr. Clark suggest that paperwork had to be submitted? But the other thing that's, frankly, a bit curious about this, if you look at numbered page 16, the day after representing to the subcommittee that the paperwork is all in, Mr. Clark writes to Ms. Fenwick-Bynum and says, please provide to my office the court documents when finalized by the court that both you and your husband, Larry Bynum, have withdrawn from the lawsuit. So he's aware that the motion to withdraw is not final on September 3rd. But he's represented to you, members of the subcommittee, that the documents you requested have been finalized. As he says in his last sentence, once the material is received, we'll move forward to allow your appointment to the Board of Health for a 3-year term. Thank you. Now, numbered page 17 and 18 represent the agenda for your September 14th meeting. And as was previously noted by Mr. Caprera, excuse me, Item 10, vote to confirm the town manager's appointment of Ann Fenwick-Bynum to the Board of Health. Motion made by Councilor Vandal, seconded by Councilor McDonald, and a roll call vote, which was to confirm the appointment. I would also point out to you the confirmation of the appointment is without any conditions, because Mr. Clark has already represented to you through the subcommittee that the conditions have been satisfied. And clearly, among those conditions is not included Mr. O'Leary's claim that Ms. Bynum cannot participate in any matters before the Board of Health involving the landfill. So what you have is Mr. O'Leary making a complaint on something that's not even part of your proceedings. None of these committee votes and council votes say that Ms. Bynum cannot participate as a member of the Board of Health in matters involving the landfill. The Ethics Commission says she cannot participate if she's got a financial interest or a member of her immediate family has a financial interest, and she cannot participate if it's going to create the impression of undue favoritism. But our position is that as of the time of this vote, she's satisfied all the requirements, because the question I ask you to consider tonight is, if it's going to be suggested that she never filed a 23B3 disclosure, when did someone discover that disclosure was never filed? We take the position as of September 14th, all the requirements were met. Now let me go on, page 19. The day after the council vote, Mr. Clark sends a letter to Ms. Bynum, and this is to confirm the council appointed you to the Board of Health for a 3-year term. The next page, page 20, and this is now February 8th, 2010. Mr. Clark is writing to Ms. Bynum with a copy to the council, to the town council. Pursuant to your request for a records review, we received from the attorney a copy of your original party registration statement. Second paragraph. Pursuant to my letter of September 3rd, 2009, I would ask that you act quickly and as diligently as possible to remove yourself and your husband from the lawsuit, and that all completed paperwork be provided to my office as soon as possible. So here we are in February, after your council vote of September, and Mr. Clark is aware that the final motion has not yet been approved by the court. But as you'll see, the motion was sent to council on August 29th by Attorney Kirsty Pesci, who's here tonight and can speak to that issue if necessary. Now, the next month, I also ask a question. In February of 2010, no issue was brought to your attention of Ms. Fenwick-Bynum's failure to remove herself from the lawsuit. The paperwork is moving through channels. On March 16th, Mr. Clark again writes to Ms. Fenwick-Bynum, in which he states that your appointment to the Board of Health was predicated upon your removal from the lawsuit against the town. To that end, you provided a State Ethics Commission decision based upon your removal, what appears to be an official plaintiff notice of yourself and your husband's dismissal of individual claims. He then goes on to state, without reading it word for word, that based upon a review of court records, that hasn't happened yet. The last paragraph, Mr. Clark says, you indicated you would take this action. I'm disappointed this action has not occurred to date. Failure to follow through on this action will result in a disciplinary process being pursued. Now, the reason I bring that to your attention, ladies and gentlemen, is Mr. Clark is suggesting that if the paperwork isn't done, he's going to move forward with discipline. And Mr. O'Leary is asking that my client be removed. So I ask you whether or not, when it's being suggested by Mr. Caprara that this is not a removal for cause, I ask you to question, based on the documents presented before you, signed by your own town officials, about what they were suggesting. Removal, disciplinary action. The next document is an email that Attorney Pesci forwarded to me that is part of the exchange among counsel. And you'll see that it's an email from Mr. Clark, dated April 15th, 2010, to Attorney Kirsch, Attorney Tirano Flores, Attorney Pesci, Attorney Scott, Attorney Gold. Simply stated, thanks to you all for your efforts. Because at that point, it's understood that everyone's agreed on the final form of the motion for Ms. Fenwick-Bynum to withdraw, and having agreed to it, it's going to be submitted. Mr. Clark, to his credit, is thanking all the parties for their efforts in bringing that to a close. And by memo to the Town Council, on numbered page 22, you'll see that Mr. Clark is notifying you with a copy to Larry and Ann Bynum that on March 16th I sent a letter to Ann Fenwick-Bynum regarding her formal removal from the lawsuit. On April 16th, we received a copy of the assent to the motion to withdraw from 10 citizen groups for Ann and Larry Bynum for the submission to the court. The last paragraph, I believe this motion is in response to my letter, and I will send a letter to the Bynums asking that when the judge formally approves this assent to motion, the final document be presented and filed with the town. And the last document in this package is the entry, the docket entry of the court, which is dated April 30th, 2010. Notice is mailed on that same date. And it clearly says that the motion to withdraw is allowed, and it had been assented to, but apparently the form of the motion was a subject of discussion among counsel. Now, I'll suggest to you, ladies and gentlemen, that this represents the fact that there were no surprises during the period between September 14th, the night of Ms. Fenwick-Bynum's appointment, and April 30th, when the motion to remove her as a party was finally allowed. There were no surprises. Mr. Clark knew what was going on. He was in regular contact with Ms. Bynum. Obviously, he had the town attorney checking the docket sheet. He was in contact and received copies, as you'll see from the next packet I'll send you. He was actually receiving copies from counsel as this motion was going through the process. So, which brings me back to a question I asked earlier. If everything was completed on April 30th, but it took between September 14th and April 30th, or July 2nd and April 30th for it to be completed, why wasn't the issue of Ms. Fenwick-Bynum's removal from the lawsuit brought to you in May of 2010 or June of 2010? Why is it coming before you in October of 2011? If it was an issue, one would assume, members of the council, it would have been an issue that would have reared its head in April or May of 2010. It didn't. Apparently, Mr. Clark was satisfied that what had to be done had been done. It took longer than everyone expected, but it was finished. So here we are in October. You're being asked to remove Ms. Fenwick-Bynum because allegedly her appointment was obtained by false pretenses as wasn't valid. Now, I'm sure that each member of the council feels that their reputation is probably one of the most important things of value to them. Family, reputation, health, those are the kinds of things that are important to all of us. Ms. Fenwick-Bynum is being accused tonight by your town attorney of obtaining an appointment by false pretenses. I asked, I'm frankly stunned that that suggestion can be made because the appointment was made after review by your subcommittee, recommendation by your manager, and I'm assuming review by your town attorney. Because if the motion to remove Ann Fenwick-Bynum from the suit wasn't good enough on September 14th, I assume he would have stood up and said, ladies and gentlemen of the council, as your attorney, I recommend you not take action tonight. Delay this matter until we get the assent. The assent eventually took another several months. But you didn't hear that from Mr. Clark. You didn't hear it from Mr. Caprara. But tonight, you're hearing only from Mr. Caprara that Ms. Fenwick-Bynum should be removed. And you have to ask yourself, why? Why is this coming about now? Is it coming about, as I suggested earlier, because she wouldn't voluntarily resign in August, prompting my letter to Mr. Clark? Is it coming about now because Mr. Clark has asked the council to approve a charter amendment, but he just doesn't have the patience to wait until the charter amendment is approved by the voters, which won't happen until next spring? No, he and Mr. Caprara are using Mr. O'Leary's complaint as the basis for removal of Ms. Fenwick-Bynum. That's as clear as day. If you try to portray it as anything other than that, we're just pretending that it's not what it's actually happening. But the simple question, ladies and gentlemen, before I give you this package, is, in so doing, if you can't find a source of authority to do what you're being asked to do you want to risk being defendants in a civil rights lawsuit like the Hull Board of Selectmen in that 1989 case? Because you're putting yourself at risk under those circumstances. I say that to you in all honesty. You're placing yourself in a position of removing an official of the town without proper due process and without a legal right to do so, which exposes you to civil rights litigation. Now, the second handout I'll give you, if I may. Madam Chairman, I'm not going to go through this whole package one by one, and I appreciate the time you've given me and the patience you've shown in listening to my comments, and I hope I haven't been repetitive, but these are documents Attorney Pesci provided to me. As I indicated, she's here this evening. These documents, in total, represent the efforts between August 29th, 2009, and April 30th, 2010, to secure the removal of Ms. Fenwick-Bynum from the lawsuit. As you'll note, in the memorandum, which is the second page of the package, Attorney Pesci makes reference to the fact as to the background of this lawsuit. And in the third paragraph, she makes clear reference to the fact that in June of 2009, Ann Bynum was appointed to the Board of Health. In the summer of 2009, she and Larry Bynum were asked to withdraw from the ongoing appeal, which asked me to do. I immediately drafted a withdrawal, a copy of which is attached here too. As is customary, I transmitted the draft to Robert Kirsch, Sarah Toronto Flores, and all the other attorneys. And the process took between August 29th, and if you look at numbered pages 4 and 5, you will see the form of the motion that is dated August 27th, 2009. So Ann Fenwick-Bynum represented to Mr. Clark. She would remove herself from the case. Attorney Pesci took the steps beginning in August of 2009 to remove Ms. Fenwick-Bynum from the case, and that was completed. And I would just briefly point out to you, as I made mention earlier, you'll see there are several versions of the motion that are included before the motion was finalized. And you will see, if I can direct your attention to numbered page 20. That the CC from Attorney Pesci is to the attorneys, and Mr. Clark is copied on that email. He's inserted on the second line of the carbon copies. And if I can also direct your attention, Madam Chair, to the very last page, page 31. In which there's an email that Attorney Pesci received from and was sent along to Ann Fenwick Bynum, in which she acknowledges that she got the notice in the mail that day that Judge Janet Kenton Walker had allowed the motion to withdraw both Ann Fenwick Bynum and Larry Bynum from the lawsuit. So, Madam Chairman, I think what that does is it confirms that starting on or about September 3rd, the day after the subcommittee meeting, Mr. Clark told Ms. Fenwick Bynum to finalize and get the motion to withdraw completed. And the motion had been prepared on August 27th, as the documents show. And that process continued. Because, Madam Chairman, as you'll note from the documents I gave you in the first handout, there's no correspondence that we've seen from everything Mr. Caprara has provided to me between September 15th, the day after Ms. Fenwick Bynum was appointed, and that memo sometime in February reminding her that she has to be removed from the lawsuit. So October passes, November, December, January. It's not brought to your attention. Apparently, there's no correspondence with Ms. Fenwick Bynum. The matter is in the works. And then February, March, and April, Mr. Clark is aware that the matter is working its way through. And on April 15th, he thanks everybody for their efforts. So, Madam Chairman, let me just wind down at this point and suggest that I don't believe that Mr. Caprara, with all due respect to him as a fellow municipal attorney, has established that if the allegation against my client was that she obtained her appointment by false pretenses, I don't believe he's satisfied that. There were no false pretenses. She sought the conflict of interest opinion. It's her position that she prepared and filed the disclosure statement as required. She then participated as a member of the Board of Health in accordance with the guidelines of the Ethics Commission opinion. She didn't participate in a matter in which she had a financial interest, she or a member of her immediate family, and by having filed a disclosure, she didn't give the appearance she was unduly influenced by the kinship, rank, or position of an individual, which is prohibited by the statute. Otherwise, if she had begun violating the conflict of interest statute with her first meeting after September 15th, why did it take until this past summer for Mr. Clark or Mr. Caprara to initiate a conflict investigation? If everybody understood what the terms and conditions were of her appointment in September of 2009, why could she participate from September to December, January through December, January through June, as a member of the Board of Health with full voting privileges, and not be cited for an alleged violation of the conflict of interest statute? I attempted to call the attorney today, Catherine Gallant, at the Ethics Commission to just advise her of these proceedings, because I wanted to explain to her I'm willing to provide any information, any documentation she needs to address her issues. I've worked with the conflict of interest law and the Ethics Commission investigators in the past. So I wanted to let her know that there's full cooperation on our part to address and resolve the issues. But the problem we have, Madam Chairman, is there's a cloud hanging over tonight's proceeding, and I'll conclude on this point. We have a cloud over the fact that there's an alleged violation of the ethics statute which hasn't been finalized yet. The Ethics Commission hasn't ruled on that. The Ethics Commission hasn't ruled on whether or not Ms. Fenwick Bynum did or did not do what she was required to do by the written opinion they gave her in 2009. So you don't have that answer. We have an issue I presented to you as to whether or not on September 12th you conducted an illegal executive session. Now, Mr. Caprara and Mr. Clark may be telling you no. I'm suggesting that the answer is yes, because here we are tonight. The end result of that executive session is not a pending lawsuit. It's the removal of Ms. Fenwick-Bynum. So that's in the process. You have a statutorily required time frame within which to respond. And then from there it goes to the Attorney General's office. So that's not resolved. And now we have an issue where it's being suggested that my client's going to be removed. And I'll just close by saying, Madam Chairman, I respectfully request that you determine that the complaint by Mr. O'Leary, while I'm sure maybe well-intentioned, is inaccurate. His claim that Ms. Fenwick-Bynum was prohibited from engaging in any activity involving the landfill is not borne out by the documents I've shown you tonight. And when he says that her vote would be obstructive or detrimental to the board's ability to engage with the landfill operator, he's talking about votes she's taken between September 15th and May 20th, the date of his letter, which is the constitutionally protected right of free speech. So if his concern is with the votes that she's taken, he may disagree with her, but that's majority rule. That's part of our democracy. And we come back to the original question. If you don't have any basis, as I said to Mr. Caprara when he showed me these documents on Friday, October 7th, if the council doesn't have any legal basis to take the action that's being requested of you tonight, frankly, what are we doing here? All of your valuable time, the issues that the town of Southbridge is faced with by you as the members of the legislative body, the town manager, the town attorney, what are we doing here tonight if in the final analysis you don't have authority to remove Ann Fenwick-Bynum from her position? And if you don't get a specific answer of a source of authority, Mass General Laws, Chapter 40, Section 21B2, such as we cite to the open meeting law, and if you don't have a case that supports that authority, then I would suggest to you that you should call it what it actually is. It's an attempt to remove a member of a quasi-judicial body, which is prohibited by your own Constitution. So even if Mr. Clark thought he had 15 reasons to remove her, and even if he was the one presenting the case rather than Mr. Caprara, your Constitution says she cannot be removed by this council on the recommendation of the manager. So you don't have the manager's participation, you don't have the authority, you're being asked to take a vote, which is clearly, as I've described, a vote to remove. Thank you very much for your patience and your courtesy. Answer any questions from the councilors, and I did want to just acknowledge if Ms. Fenwick-Bynum may have a moment to address the council.
Why don't we do that before we take a break?
If there are no questions?
Yep.
Thank you.
I don't know. Do any councilors have any questions for Attorney Brackett? Okay, thank you. Thank you, sir. Mrs. Bynum?
Good evening. My name is Ann Fenwick-Bynum, 79 Dennison Hill Road. Back in 2009, I started the process of joining the Board of Health. In the process, Mr. Clark asked for a state ethics opinion, which I provided, in my withdrawal from the lawsuit. I started the withdrawal of the lawsuit on August 27th when Attorney Pesci signed the papers and sent them into the courts. I was hindered at all stops along the way by incompetence in this town hall. It started with the hearings. During the hearings, I filed a petition to represent 10 Hispanic people on Mill Street who were being violated and had no voice in this town. My papers were lost. They were turned in to first they were turned in to Nick Tortoise, who said he gave them to Nancy Kaplan, who said they were given to Chris Clark to be left in the town hall. Then I went to Mattie Dowse, she didn't have them. Jim Moran didn't have them. Jim Philbrook didn't have them, nor did Max Gullickson. It took forever to get the attorneys, Kirsch, Scott, Flores, to sign the papers to release me from the court. I did everything within my power. I initiated the process. I didn't believe it would take that long. Mr. Clark knew it wouldn't take that long. The papers were missing. They belonged in this town hall. They disappeared from this town hall. Now my ethics disclosure has disappeared from this town hall. On August 1st, I had a discussion. Mr. Clark invited me into his office where I felt intimidated, humiliated, threatened to walk in and be sitting with a police officer sitting there for a discussion while I was being told to resign from the Board of Health, or he would make known to the public my civil and criminal activity. It wasn't a choice of his offering me to resign or he would make it public. If I had done something wrong, his obligation and due diligence to this town was to report me, but he gave me a choice. I sat there and listened to his insults, and Mr. Caprera, I did not get emotional. As you said, that was a squirrely statement on your part. I sat there and listened. When I asked a question about who made the charge, I was told it was anonymous. Then after about 20 minutes, Mr. Clark changed his mind and told me it was a Board of Health member. When I mentioned I knew who the person was because of an IP address, Mr. Clark got very red and his carotids distended. There was no going forward with a discussion at that point because I wasn't being told the truth. So I told Mr. Clark he could do what he had to do, and I would call my attorney. And that is what's brought us to this point. My ethics disclosure is missing from this town hall. My 10 citizens group is missing from this town hall. I made another ethics disclosure in August, and it is on record. It is on video, it is on digital, and it will be put in the town hall. And this time, I will have a copy of it. My disclosure was brought into this town hall to Mr. Clark, and it was turned into his office on August 6, 2009. It was the same day I brought in my 3-page paper from the Ethics Commission. I got 3 papers. I don't have the 4th. I didn't keep a copy because I believed you could trust employees here. I do not have it. I am sorry it's come to this point. I feel my civil rights are violated. You people went into executive session, and I am making the statement. You went into executive session on 2 occasions and discussed me. Mrs. Nicola, you made a statement that you didn't like me, and I feel bad for you that you're such a shallow person. Thank you.
We'll have order now. I'm calling a short recess, and I will return in 10 minutes. Okay, we're going to continue with the meeting. And at this time, the town attorney wants to address some of the things that were said by the previous speaker. Thank you.
Thank you, Madam Chair. Just a couple clarifying comments. I stated at the beginning that I had so much information that I was going to try to limit my comments, and I did. But now, in view of what Attorney Hackett has mentioned, I will extend my scope a little bit because it needs to be said. Needs to be louder? I'm sorry, did I say, I'm sorry. My apologies. You know that I know that. I'm sorry. First of all, starting with comments made by Mrs. Bynum, there was a frustration that it was the fault of the other lawyers in the lawsuit that delayed the filing of the motion to allow her out of the lawsuit. Within the packet of documents are several iterations of the motion prepared by her attorney. And in the first several iterations, there was a line at the end stating essentially that the dismissal, the removal, the exit of Larry Bynum and Ann Bynum would not affect the standing of the case. Lawyers pick up on these things, others don't. But the fact is that it was a strategic problem that the attorney had in the case, that if the Bynums were let out, potentially the 10-person lawsuit would fall apart, the plaintiffs would dissolve and be out. And so there were clauses put in several iterations of the motion by Attorney Pesci trying to get the other lawyers to sign that, and they didn't want to, and I don't blame them. It's not easy to get out of a lawsuit. It's not a matter of right to get out of a lawsuit. Under Massachusetts General Law 231-6F, if you go into a lawsuit and sue someone frivolously, you can be sued at the end for all of the costs and damages. So you just can't be a drive-by lawsuiter and sue people and get away with it in Massachusetts. There is control that the defendant has to not let you out. You start the fight, you finish it. And at the end, if it's a slam dunk win for the defense, they're going to motion under 231-6F for costs. So you just can't get in a lawsuit and just get out. You know, I'm going to take my ball and go home. You can't do that. And in this situation, there was a strategic exodus attempted by Attorney Pesci by not wanting to lose standing as the case was going along. And if you trace the motions and the emails that are part of the information, it wasn't the fault of those lawyers. Finally, the last statement was a modification of the standing, but by that time, the case had already gone forward a long way. So I would pick up on that as something important. A passing thought, and it's all for your consideration. It just strikes me very strange that the disclosure document under 23B3 that would protect someone for future claims would be treated as a very important document, and I, for one, would keep numerous copies of it. There's a statement that she turned it in but doesn't have copies, and I think that speaks to whether or not they were actually turned in. It's not the kind of thing that you won't want to prove at a later date, hence what we're going through today. Several further comments, just clarifications. There was a comment by Attorney Brackett, I apologize for the first, that Dr. O'Leary was pulling information out of the air regarding restrictions on Mrs. Bynum being in the lawsuit. They come from the first paragraph of Attorney Duca's ethics letter of July 20th, 2009. And I read this before, but I'll read it again. First, Attorney Duca writes, "You state," and when the word "you" is here, it's a letter to Mrs. Bynum. So you, Mrs. Bynum, state that you have formally removed yourself from a lawsuit against the town and its Board of Health involving the expansion of a landfill based on the allegation that there was never a proper site assignment. The next sentence, you further state that you will no longer participate in any further meetings or discussions with the attorney representing the plaintiffs in the lawsuit or any landfill issues / site assignment issues. That appears to be a commitment made by Mrs. Bynum to this lawyer to get a written opinion. It wasn't imposed on her, it was imposed by herself on herself. And that is a reference that apparently Dr. O'Leary made. Comment on the actions of the town manager at and around the vote of September 14th, 2009. and maybe because I'm being punchy and my wife will kick me when I get home, but it struck me strange sitting hearing my brother attorney, in effect, saying that his client couldn't be trusted. What do I mean by that? The allegations were that Mr. Clark was in the wrong by sending the information forward to subcommittee and then full town council. He was told that she was off the lawsuit, and he believed her. And why didn't he do something for so long? He believed her. And to go on for a time pointing to this paragraph and that paragraph, it looks like in those writings like a person who believed her. And so I guess the flip side of the comment is, fool, should have believed her. And sitting there, I guess got frustrated because of that, and I'm going to get spoken to by my wife when I get home. But I think what the paper trail reflects is that Mr. Clark was told she was off the lawsuit, and he believed her. And that information was passed up the chain through subcommittee and committee who believed her. And why shouldn't y'all? But it turned out that it wasn't true. Even Attorney Duca acknowledges from Mrs. Bynum that you state you have formally removed yourself from a lawsuit against the town and its Board of Health. Mr. Clark got this and read it. Why shouldn't he believe her? There was comment about executive session. There have been 2 previous executive sessions. Executive sessions are tricky. And there are 10 exceptions under the law to go into executive session. One is if there's litigation, it's the 3rd. And Attorney Brackett seemed to be imposing a very tight standard on us dealing with this difficult situation in making a choice after receiving his letter that threatened lawsuit, made reference to the Constitution and laws, cease and desist. As attorney for the town, I truly felt that there was a very imminent lawsuit. And so we went into executive session. And I think the same standard needs to be applied to us in going to executive session. When Mrs. Bynum made the motion at the Board of Health meeting of March 24th, 2011, to go into executive session, the vote reads, the motion is, motion made by Ann Bynum to enter executive session under MGL Section 23B to discuss strategy relating to litigation with a site assignment of wood processing facility. And then there's all kinds of information where Mrs. Bynum was in the discussion of why there's possible litigation with Casella and what they would do if they didn't file for the site assignment, and so on and so forth. That lawsuit wasn't on the horizon, and it never existed, but you went into executive session. You were in executive session for 2 hours and 1 minute on a unanimous vote. And I just think, in fairness, the same analysis for going into executive session should be applied to this council as to the Board of Health. There was comment about the authority for this board, this council, to entertain and vote upon the motion that's before them. And the concern was posed in a way that lawyers know how to do it and can pick up on each other, but the public commonly isn't aware. And it's the argument of silence. It's called the argument of silence. You are being attempted to be put in an uncomfortable spot by the query, you show me the law that allows you to do this. If it's not there, then you can't do it. The preliminary question, and I mentioned before that this is a peculiar situation we find ourselves in. The preliminary question to that discussion is, what reasonable person would ever expect to find in our charter or bylaws guidelines to help us navigate through this mess caused by Mrs. Bynum? What reasonable person would expect to find that? I mean, I would tell you that in my car manual, they don't give me directions for how to back out of a phone booth. Because no person would expect you'd have to do that. You don't write regs for that. You don't write guidelines. And so to argue strongly and argue the argument of silence loudly, you show me what's not there, and if you can't show me it's wrong, is a lawyer's ploy. Lawyers pick up on it quicker than people. But we do have guidelines for this motion. It's found in the powers of the council. The council section is 2, and at 2-4-1, it says, except as otherwise provided in this charter, all general, corporate, legislative, policy-making, and appropriations powers of the town shall be vested in the town council. Or in a cleaner reading of that, except as otherwise provided in this charter, all general powers of the town shall be vested in the town council. You were asked to take a vote to approve Mrs. Bynum on September 14th, 2009. You did that vote on what you thought was true information. Your responsibility to the town is to vote as well as you can and make right what might be wrong and lead the town with your general powers given in the charter. You additionally have all taken an oath when you assumed the position of town council. And it effectively said, do you, town councilor, solemnly swear to perform all duties incumbent on you as a town councilor for the town of Southbridge until, whenever your term was up, faithfully, impartially, and according to the laws of the Commonwealth, and abide by the charter and bylaws of the town of Southbridge, so help you God. That was the oath you attested to abide by the law. The peculiarity of this whole situation, and it's difficult for us to put, we're dealing with round pegs and square holes. It's a very uncommon situation. So the difficulty is that Mrs. Bynum swore this same oath when she took her oath on September 21, 2009. And she swore, do you, Anne Fenwick Bynum, solemnly swear to perform all the duties incumbent of you as a town councilor for the town of Southbridge until, it would have been June 2012, faithfully, impartially, and according to the laws of the Commonwealth, and abide the charter and bylaws of the town of Southbridge, so help you God. And the town clerk says that she swore that oath. The fact was, at the instant, and this is so ironic and weird, but at the instant she swore that oath, she was in conflict of interest and in violation of Chapter 30B, 268A, 23B3. When she became a board member, she became in conflict of interest. And I'm not making that up. That's the phrase that her attorney used in the motion to get her out of the suit 7.5 months later, that she was in conflict of interest. So to swear this oath, she put herself in breach of the oath. And so it's just a crazy problem. And so what do? You are vested with all the general powers all the general powers of the town should be vested in the town council. A vote was taken, your council voted it, and it would be appropriate, and I believe your town citizens would want you to right what is wrong if you feel it's wrong. You have the power to do that. Let me conclude by saying this. You don't know the full taste of a meal until it's finished. And you don't know the full flavor and the full understanding of a thought until you stretch it out to completion. Attorney Brackett is trying to encourage you not to vote. And in doing so, that would make you set a precedent. And what's the precedent? And truly, Mrs. Bina, I'm not trying to be antagonistic. This is not my horse race. I'm not going to call this the Bynum rule or the rule of Bynum. We'll call it the rule of Smith, the Smith rule. What's the Smith rule? If you don't vote and set a precedent, the Smith rule is this: the ends justify the means. That if you do something wrong, whether it's misrepresentation, fraud, deceit, false pretense, to gain something, property, recognition, honor, and if you can hang in there for 7.5 months and no one calls you to account, then you're golden. That would be the rule of Smith. That's what you'd be doing if you don't vote. Not acting is as much a choice as acting, and all choices have consequences. And if you don't vote, that is the rule you would be adopting. And we just call it the Smith rule. And just take it to the logical conclusion. Finish the meal. You want to teach that rule to the kids in school? I was raised in the town. In 1960, Mrs. Dragon was my first grade teacher at Eastford Road School. The first thing I remember her teaching me was the golden rule. And it has stuck with me all my life. I learned that rule and followed that rule. Maybe we should teach the kids the Smith rule. Ends justify the means. Do what you can. If you can get away with it for 7.5 months, then it's okay. That's ludicrous. I know it's ludicrous, and I'm saying it so it would be felt and heard and sensed to be ludicrous. This whole situation is ludicrous. Not because of what you folks have done. It's almost a municipal train wreck. And we're having to deal with it. And it wasn't the council, it wasn't the manager, but it was Mrs. Bynum who bent the rail and got the train crashed. Now we're trying to fix it. And we're trying to move on. And by not voting, that's a choice with consequences. And to round this out, I would say, as the town attorney, I am making this oral opinion that you as a council do have authority to vote. This motion is not inappropriate, and my opinion is that you can vote.
Yes, you may. Thank you, Mr. Caprara.
Well, Madam Chairman, I'll ask you to focus on the language that Mr. Caprara cited from the Charter, Section 241. And the language begins, except as otherwise provided by this Charter. Well, the except as otherwise provided by the Charter is Section 4, which I pointed out to you at the beginning of this hearing, power to rescind appointments. So you have general power except as otherwise provided by the Charter. So when the Charter, as drafted by either the Charter Commission or this Council, and then presented to the Attorney General for review and presented to the voters for acceptance, in the Charter you said this is how we want to handle the power to rescind appointments. Now, if this wasn't here, I might agree with Mr. Caprara, and we'd all take a moment to observe that we're in agreement on an issue. I might agree with him that you're exercising the general power of a council. Southbridge is technically a city form of government. Chapter 39 of the general laws gives cities general powers, above and beyond what you may have specifically under your charter. Article 9 or 10 of your charter, transitional provisions, will say, except as otherwise provided by this charter, you exercise all the rights that a city has under the Mass General Laws. So you have two levels of regulation. The general laws provide powers to cities, and your charter gives you certain powers. But in each case, it says, except as otherwise provided by law. You have law here, the law of the town of Southbridge, your constitution. So we don't have to make up the Smith rule or the Bynum rule or anything else. It's already been done. The people who went before you, either as the first members of this council going back to the late 70s, early 80s, the people who were on the Charter Commission that adopted this charter in its original form, they decided, well, what are we going to do when it comes to appointments by the town manager? Well, if it's an appointment to other than a quasi-judicial body, the manager has the power to rescind subject to your confirmation. And then it gives a whole listing of reasons. Excessive unexcused absenteeism, incapacity, inefficiency, insubordination, conduct unbecoming. Conduct unbecoming is a pretty broad category. But the Charter Commission and the Council and the Attorney General in approving and your voters said power shall not apply to quasi-judicial bodies. So the simple statement is you don't have the power Mr. Caprara says you have, because that section under 241 says except as otherwise provided by the Charter. And the Charter provides. So there you have to look to the specific terms of your power. Just a couple of other brief points. Mr. Caprara raises an issue about the March 24th, 2011 Board of Health meeting, and there was an executive session. I'm assuming that if this was reported to him as town attorney, he would have investigated to determine whether there was pending or imminent litigation at that time. If not, I assume he would have spoken to the chairman and said, let me suggest to you that in the future you need to have the following to do an executive session. Now, if that took place 7 months ago, I'm assuming it's been remedied by an opinion from the town attorney to the Board of Health. You can only go into executive session to discuss litigation as follows. When the open meeting law was adopted as revised, we sent a memorandum to our 10 client communities telling them this is what the new open meeting law says. The Attorney General has enforcement, not the Worcester DA. This is how you post a notice. This is how you make a complaint. What used to be exemptions 1 and 2 have now been consolidated into 1. So you send out a memo and you tell your boards and commissions this is how you operate under the new law. I assume that was done, including executive sessions for litigation under the Attorney General guidelines. They've given you a handbook. And I will tell you, having worked with Patricia Smith, the Assistant DA in Worcester, on open meeting law issues for the last 25 years, and when I worked in Watertown under the Middlesex DA, who was then Martha Coakley, the district attorneys, even before, and Martha Coakley is now the Attorney General, the district attorneys say pending or imminent. Now, if Mr. Caprara has a citation to some other category other than pending or imminent, today's October 19th, I haven't filed a lawsuit since August 10th, so what was imminent about my letter? With respect to the trust factor, once again, I mean, we're tossing around issues here that don't have a monetary value. They have an importance to my client, and they should have an importance to any member of this council. You talk about trust, the trust of an appointing authority, Mr. Clark, and his appointees. Well, Mr. Clark didn't go into this blindly. Mr. Clark, in his letter on September 3rd, page 16 of the handout, the day after he reported to the committee that the paperwork was in, the report of the committee says, Mr. Clark stated that the information requested from Ms. Fenwick-Bynum had been received. Well, that's one sentence. How else do you interpret that? He's received what was asked for at your previous meeting. And then on September 3rd, he says to her, please provide my office with the court documents when finalized. So he knew the process had begun on or about August 27th. He's specifically acknowledging they're not finalized on September 3rd. And I'm assuming that Mr. Clark, as an experienced town manager, knew on September 14th, when you confirmed the appointment, the documents weren't finalized. So where's the violation of trust here that Mr. Caprara talks about? Mr. Clark knew in February that the documents weren't finalized by his letter that I've also included here. He knew in March, and he knew in April before the documents were finalized. So where is the violation of trust Mr. Caprara is somehow or other hanging his hat on? Mr. Caprara has confirmed my suspicion that Dr. O'Leary was reading the conflict of interest opinion. Well, if Mr. O'Leary felt that Ms. Bynum had not complied with the ethics opinion based on the facts she presented, I'm assuming that back in May, there would have been at least some attempt to clarify that. Mr. Clark to Ms. Bynum, and what did you mean when you made that statement in your email? Did you mean you wouldn't talk to Kirsty Pesci at all regarding the suit or any matters before the Board of Health? Or did you say you wouldn't participate in any matters before the Board of Health? Why wasn't that attempt at clarification made for a sitting member of a regulatory body? Why are we here tonight trying to decide whether she did or did not misrepresent the facts? Nobody apparently has asked her that before tonight. And lastly, the issue of delaying the filing of the motion. I think that's completely unfounded. The motion was drafted and presented to opposing counsel on August 27th. Mr. Clark advised the counsel on September 2nd. The paperwork was in. If Mr. Clark wanted to say to this counsel, I don't want you to confirm this appointment until I have a court order that Ms. Fenwick Bynum has been removed from the suit, all he had to do was say that. And that would have been the condition precedent to your confirmation. He didn't say that. And your appointment on September 14th doesn't have any conditions. It doesn't say, we appoint Ann Fenwick Bynum on the condition that within 30 days of September 14th, you will be removed from the lawsuit by action of a Superior Court judge, or 60 days, or 90 days, or 120 days. It contains no conditions. So, members of the council, thank you for the time. Again, I respectfully request that when I ask you to take no action, it's for two reasons. One, the allegations in the complaint have not been proven. And if any one of you was the subject of a complaint, the first thing you want to know from the person reviewing it is, have these allegations been proven? The answer tonight is no. Secondly, even if Dr. O'Leary was here testifying, your own charter says Mr. Clark and Mr. Caprara, however they label this proceeding, don't have the authority to request you to take this action, and you don't have the authority to take the action. So the question is, Ms. Fenwick Bynum should be allowed to serve the balance of her term. And if Mr. Clark is not happy with her performance, I will acknowledge on the record there is no right to reappointment to a position in municipal government. I've tried that case in U.S. District Court in Worcester. So since there's no right to reappointment, then if Mr. Clark isn't happy with the experience of the last 2 years, he clearly has an avenue available to him. But if he tries to remove her at the end of 2 years, in violation of your charter and my client's First Amendment rights, then I suggest to you he's putting you, the members of the council, at risk. Thank you.
Attorney Caprara.
Thank you, Madam Chair. Just a quick clarification. Our charter in Section 2 speaks to the council. Our charter in Section 4 speaks to the town manager. The removal power quoted by council is from Section 4 as to what the town manager can or can't do. But we're being asked, what authority does the town council, Section 2, have tonight? And they have all power, general power, to act. They voted September 4th, 2009, and they have a right to clear up their votes, and they have power to do that. So there was maybe you haven't read our charter that clearly, but 2 is for the council, 4 is for the town manager, and that language came out of 4.
Thank you. Go ahead, Counselor.
Thank you. With no disrespect to Attorney Brackett, I'm not a lawyer. When this was coming up, I did a little research, and there are a number of federal cases that point to the absence of statutory silence. You look to the legislative body to make the decisions if there's no power to removal stated. But being, again, not a lawyer and being very concerned, I called the AG's office, and I questioned the absence of statutory silence in the removal of a board member, a quasi-judicial board member, to which they also said to look at your legislative body. And when I was concerned about that action, I was also informed to follow our council, to go to our town council for an opinion and for their advice, whoever that may be. And frankly, I'm very satisfied with that. And I also would like to just point out that it's unfortunate that our minutes are not as thorough as they need to be now. Now, new open meeting laws tell us to take much more thorough minutes at meetings and really reflect the intent and the feeling that was going on during the discussion. And I certainly hope in the future that that's what happens with our meeting minutes. But certainly those meeting minutes don't reflect the entire conversations and the commitments that were made, having been there. So that's all I want to say. Thank you.
Thank you. Is any other counselor? Counselor Regis.
Thank you, Madam Chair. First, if I could, I guess, ask your indulgence. It's been a while since we heard the actual motion that Councilor Livingood made. Sure. So if I could, the motion is to acknowledge and confirm that Ann Fenwick Bynum's appointment to the Board of Health by the Town Council at its regularly held meeting on September 14th, 2009, was obtained by false pretense, and therefore it was and is invalid. If I could, Madam Chair, I would like to propose an amendment to that motion, that being to acknowledge and confirm that the town manager's appointment, that the town manager's appointment of Ann Fenwick Bynum to the Board of Health, I'm trying to think what I want to say, that our confirmation of the town manager's appointment to the Board of Health by the Town Council at its regularly held meeting on September 14th, 2009 was obtained by false pretense. We don't appoint, is what I'm trying to get at. I believe that the motion as it sits right now is that, it says Ann Fenwick Bynum appointment to the Board of Health by the Town Council. We don't appoint. We confirmed the town manager's appointment. So if I could, I'd like to make that in the form of a motion, that amendment.
Can you repeat that? Could you repeat what, did you write that all down?
I think she wants to take out.
Okay. Yes, please.
I highlighted the section where she wants to confirm your confirmation of the town manager's appointment versus just saying it strictly as the appointment from the council. It's not going to be town managers.
We do not appoint. We confirm the town manager's appointment.
I understand your point. I just want to hear it. I want to hear how it came out, because I want it right.
Our confirmation of the town
I haven't
manager.
been sitting here for almost 3 hours to vote on something that isn't right. Motion will be to acknowledge and confirm that your client's appointment to the Board of Health by...
I highlighted our confirmation of the town manager's appointment. That specific area entered into the original motion.
The motion will be to acknowledge and confirm that your client's appointment to the Board of Health by the town manager and the town council confirmation at its regularly held meeting on September 14th, 2009 was obtained by false pretense, and therefore it was and is invalid. Okay? Does that work? Is that how you want it to read? Counselor?
I apologize. Can you say it again?
Okay. The motion will be to acknowledge and confirm that Ann Fenwick Bynum's appointment to the Board of Health by the town manager and the town council confirmation at its regularly held meeting on September 14th, 2009 was obtained by false pretense, and therefore it was and is invalid.
No, that's not what I'm saying, because then that says that the town manager's appointment
and the town council's confirmation.
I don't want to make a...
I think maybe what the point is, and my name has been used a lot in vain tonight, but my understanding is that I do the appointment. In this circumstance, it was the council that put that condition on, and I believe where you're headed is that it would be the council seeking to have that condition that was placed on there was actually done, obtained under false pretense. So it was the council condition.
Okay.
Our confirmation of your appointment
Okay.
Right.
Yeah,
was obtained by false pretense. That's what I'm
Is
saying.
that all right?
Our
Okay.
confirmation of your,
Town
personally
council
for me,
confirmation.
Okay.
Town manager.
our confirmation of your appointment, my vote to that effect.
The motion will be to acknowledge and confirm that the confirmation, the town council's confirmation of Ann Fenwick Bynum to the Board of Health at its regularly held meeting on September 14th, 2009, was obtained by false pretense and therefore it was and is invalid? Is that what you want?
Yes.
Okay. Do you have that, Stacy? You have that? Okay.
I will, yeah, it'll be.
All right, that's the motion.
It's amended motion. So we vote on the amended motion.
So we need to vote on the amended motion.
Madam Chair,
Yes?
can we really have her read it back, though?
Yes. You
That's what I
certainly
want.
can.
Thank you.
Could you do that for us, please?
To acknowledge and confirm the town council's confirmation of Ann Fenwick Bynum,
To the Board of Health
appointment to the Board of Health, okay. At its regularly scheduled meeting on September 14th, 2009, was obtained by false pretenses and therefore wasn't valid.
It was and is invalid.
It was
It
and
needs
is.
to be exact, please.
Okay.
Can you read yours again? Just-
The way I want it to sound? Okay, or the way I think it should sound? The motion will be to acknowledge and confirm that the town council's confirmation of Ann Fenwick Bynum to the Board of Health at its regularly held meeting on September 14th, 2009, was obtained by false pretense, and therefore it was and is invalid. Okay? The wording okay? That's okay, and we've made a motion. You've seconded. Could I have a roll call, please?
Oh, I'm sorry. Mic's on? Okay.
Shouldn't tell- Did you recognize him?
Might I point out?
Could you
To me-
identify yourself, please?
I'm sorry,
Yes,
Kenneth
please
O'Brien,
do.
858 North Woodstock Road.
Yes.
As I understand it, the chair is an English graduate, a graduate majoring in English.
And what that has to do with this, could you
Well,
please
I'm about
just
to
speak?
make that clear.
Okay.
If you read the structure of that sentence, it is not clear who made false pretenses.
It doesn't have to. Motion will be to acknowledge and confirm that the town council's confirmation of Ann Bynum, blah, 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 to the Board of Health at its regularly held meeting on September 14th was obtained by false pretense.
It includes a name.
And therefore it was and is. No. It doesn't need to.
No.
You have
It's very clear.
It's all in there. It's extremely clear, and it's fine.
Confirmation. False pretenses.
Yes.
833 Pinedale Street, James Satilli. You acknowledge me?
Yes.
Okay.
Yes means I'm acknowledging
Okay.
you when I'm looking
Well,
right
you had a
at you.
blank stare. I have two things two points to make. One, I don't even know whether you can reach back into a former council to change a vote. I believe that may be somewhat outside the law. Two, you folks are exposing us taxpayers to a liability because of a possible ego trip you may take to challenge Mrs. Bynum in a courtroom. You are exposed to individual liability. Keep that in mind. By doing that, you expose us because we got to pay the bill. Thank you very much.
You're welcome. If there's no further discussion, would you please do a roll call?
He's not a resident.
No. No, sir. No, sir. We're going. We're going. Could you please give us a roll call? No.
We're voting on the amendment.
No.
Counselor Livingood?
Yes.
Counselor Nicola?
Yes.
Counselor Regis?
I apologize. We're voting on the amendment, correct?
Yes, we are.
Yes. Okay, yes. I'm sorry. Yes.
Counselor Spinelli?
Yes.
Counselor Vandal?
No.
Counselor Clements?
Yes.
Counselor Langevin?
Yes.
6 yes, 1 no.
Thank you.
Now, Madam Chair, if I could, do I still have the floor?
Yes.
Thank you. I made a bunch of notes, and I apologize if I'm all over the place, but Attorney Caprara prefaced his comments by saying he was instructed to keep this simple. And I fully subscribe to the KISS method myself, so I'm trying to do that. Ms. Beinemer, in her comments to us, stated that many of the town hall employees, I guess, are derelict in their duties because all this paperwork is missing. She hints probably to a conspiracy, something like that. So we're talking about rules, the Beinemer rule, the Smith rule. Here's a rule, CYA, okay? Keep copies. If these things, if you think, if I had any inkling that there may be a conspiracy against me or someone didn't like me, or you better believe I would keep triplicate copies of everything I ever did. That's my comments about that. And as far as dereliction of duty, if you go through this information that Attorney Brackett provided to us in some of these email chains, it's amazing to me. From Kirsty Pesci to Attorney Flores, April 14th, 2010, Attorney Pesci writes to Attorney Flores that Ms. Beinemer was working with the Board of Health and Michael Scott to locate all these records, and they weren't located, and that she had first presented the motion in August of 2009. Attorney Flores wrote back to Attorney Pesci on April 14th, 2010, stating that she did, in fact, present the motion in August of 2009, but then rather than informing Attorney Flores that paperwork may have been lost and we don't know what happened, Attorney Flores states that we then heard nothing from you until March 26th of this year. So why wouldn't your attorney be informing the other attorney that, listen, we're trying, we're looking for this paperwork? Nothing, heard nothing, nothing.
Okay. Could we
To
have some
continue,
order,
if I
please? Really?
To
No.
continue.
No. Go ahead, Counselor.
And I take offense, actually, to Attorney Brackett bringing in, referencing the Hull decision. The Hull decision is the action taken by the Board of Selectmen violated the members of the Redevelopment Authority, their First Amendment rights, because of their votes, voting contrary to the wishes of the Board of Selectmen. I fully support members of this council, members of any multiple member bodies, citizens. You vote your conscience, you speak your conscience. But I do have a problem, and this in no way, my vote tonight in no way questions Ms. Fenwick Beinemer's votes for those things, on those things that she was legally able to participate in. Not at all. So that, I do not feel, is a valid reference to what's going on here right now. I made the motion to amend the original motion, and I am going to be voting yes on the amended motion. Thank you, Madam Chair.
Thank you, Counselor Regis. Does anybody else wish to weigh in on this amended motion? Yes, you may. Briefly. Timing it.
Madam Chairman, as a matter of municipal law, since this council is sitting in judgment of my client, my simple question to you is whether you plan on making any subsidiary findings before you move to the final motion. And those findings would be findings of fact based upon the information you've received here for the last, as you pointed out, almost 3 hours. Since this is a motion that alleges false pretenses, then I'm assuming at some point you're going to specify exactly what those false pretenses are, because anybody reviewing this matter would have to determine what is it about Dr. O'Leary's complaint, because that's the complaint that's before you tonight. It's apparently not the complaint of Mr. Caprara or the members of the subcommittee or Mr. Clark. Mr. Clark, I think I heard him make some reference to a condition. Well, as we all know, the only way you incorporate a condition into a motion is you make an amendment, as Councilor Regis did just a few moments ago, and you incorporate the condition in the motion. So if Mr. Clark's trying to suggest to you that you have a condition in the September 14th vote that wasn't in the motion, how do you do that? You all know, I'm sure, as experienced members of the council, that unless it's incorporated in the motion, it has no power, no binding effect. So I'll come back to my original question. In the absence of subsidiary findings, I will once again raise a question about the validity of this entire proceeding. Thank you.
Thank you.
And by the way, to Member Clements, I've worked with the Attorney General's office for 35 years. They don't give advice to local officials. They say, talk to your town council. And whether it's Kelly Gunnigan or Bob Ritchie before her, they defer to town council. And apparently, if you want to take the advice of town council that you've got the authority to take this action, I would suggest to you, if the Attorney General's office was weighing in this matter, they would disagree with Mr. Caprara.
That's your opinion. Thank you.
Okay. What do you want?
Madam Chair, I think that, and Attorney Caprara brought this up, that all the material that he submitted was part of his material for the discussion tonight, which the attorney has received and received well in advance of tonight's meeting. And I think a 3-page letter that was included and sent to him on October 6th clearly lays out what the case is against his client. Thank you, Madam Chair.
Thank you.
The letter is just a letter. It's not a vote of this council that's finding any subsidiary findings of fact in support of your ultimate decision. Unless, of course, Mr. Caprara. Unless you're suggesting Mr. Caprara is a fact witness in this proceeding. I understand that the inventory of the documents you've received will be incorporated as part of your minutes. But right now, the only thing you have before you is a motion to take action on the motion as amended. And no subsidiary findings on the allegations contained to hear the complaint or charges against my client. And I would simply suggest to you that no one of your other boards or commissions, zoning, planning, conservation, Board of Health, or any other of your other boards or commissions would make those kinds of decisions without findings of fact. Otherwise, it'll be tossed out by a reviewing court. Thank you.
Thank you. Anything else you want me to add to this? Okay. Well, we have this amended motion in front of us, and did I get a second on that? Okay.
But I think we need to amend the motion. Yes. A motion to amend the amended motion.
What is your motion?
I would suggest, as has been suggested, that we add a little bit of language that the information provided to subcommittee, the confirmation based, I just had it in there. The information that the confirmation was based on, presented to subcommittee and council, was Where's the full
ahead.
motion? Sorry.
Read
I'm
it.
just saying if we add that in, because I know that the information that I received was why I voted the way I did. So if we're saying that it was a falsehood, a pretense, false pretense, then I would say that the information provided to the subcommittee and its recommendation to full council for this appointment, the confirmation was based on the false information provided. So I would say that we just need to add some of that information in there, you know. How do we want to know?
Look at her and say it again so that she can.
Just a little slower, I'm sorry, I'm trying to get it all.
Yeah, no, I'm just thinking how we want to, I'm being very forthright here over the mic. We're saying that it was obtained by false pretense. The confirmation was by false pretense, and I'm saying that the information to make that confirmation that was provided to subcommittee and the full council was obtained by false pretense, and therefore is invalid. I'm not sure if anybody wants to help on that.
Madam Chair?
Yes, Counselor.
I don't think anybody up here knows what they're doing, to be honest with you. I mean, back and forth. I mean, we got a lawyer over here, you're getting questions, you know, information from him, information from Denise. Before we get into a lawsuit, all right, I'm not that foolish. This seems like it's going for a lawsuit. And they're going to come after you people individually, and you're not covered by the town, all right? So maybe we ought to not be too hasty in deciding on this tonight, because from what I see, you're all confused, and I'm a little confused myself. Thank you.
If I may, Madam Chair, a clarifying factual determination would be defining the false pretense that she said she was off the lawsuit. I'm almost
Excuse me.
this thing.
I've had just about enough from the peanut gallery. Please be quiet, or I will ask to have you removed. Yes.
If I could,
Yes.
I'll speak up. Thank you for reminding me. The clarifying part of the motion could be that the false pretense was that she said she was off the lawsuit. I mean, you can't be half pregnant. You're either pregnant or not. You're either in a lawsuit or you're not. On September 14th, 2009, she wasn't off the lawsuit. People believed that she was. She led them to believe that she was. That's the false pretense. So just clarify the false pretense of stating that she was off the lawsuit.
After false pretense statement.
Madam Chair.
Thank you, Mr. Cooper, for clarifying that.
Madam Chair.
Just a moment, please. I know that.
I'm just following back.
Read to me what you have on
Do you want it
the
with?
existing motion.
Okay. To acknowledge and confirm that the Town Council's confirmation of Ann Fenwick Bynum to the Board of Health by the Town Manager at its regularly held meeting on September 14, 2009 was obtained by false pretenses and therefore...
Stop. False pretense. In that Mrs. Bynum stated that she was no longer involved in the lawsuit against the town and the Board of Health. and, comma, therefore, comma, it was and is...
I'm sorry, I'm still catching up.
Okay. Where are you?
And Mrs. Bynum stated she was no longer
Involved
involved
in the lawsuit against the town and the Board of Health, and, comma, therefore, comma, it was and is invalid.
And Mrs. Bynum stated she was no longer involved in the lawsuit against the town and the Board of Health, and therefore, and was and is invalid.
And therefore, it was and is invalid.
Okay,
Okay?
thank you.
What did you have, Counselor?
Refresh my memory. Wasn't the affidavit vote 4-4? For the affidavit that, you know, people signed, that said that it was, they voted under false pretense because...
Only 4 counselors that were sitting signed that affidavit. There were only, on this council, on this sitting council.
Right.
There is myself, yourself, Counselor Regis, Counselor Clements, and Counselor Livingood. There's 5 of us that were on the town council at the time that
And all 5?
this was voted. There are 4 signatures.
To 1.
You didn't sign anything.
I didn't want to sign it.
Well, that's fine. You don't have to. Nobody forced you to. That's fine. Okay. So what do you mean 4-4?
I thought it was 4-4. I must be mistaken. Thank you.
Okay. I'm not sure I know what you mean, Counselor. Do you?
Pardon?
What do you mean?
I said I was mistaken.
Okay.
Thank
All right.
you.
Thank you. All right. Now I'm going to, for the last time, ask you to please read that. I'm assuming this is coming up for a motion to amend. So before you even read it, do I have a motion to amend the existing motion?
Yes, I made a motion.
You made a motion.
Second.
Now can I hear it, please?
To acknowledge and confirm that the Town Council's confirmation of Anne Fenwick Bynum to the Board of Health by the Town Manager at its regularly held meeting on September 14, 2009, was obtained by false pretense, and Mrs. Bynum stated she was no longer involved in the lawsuit against the town and the Board of Health, and therefore it was and is invalid.
Okay. Now I'm going to read it, and this is how I want it to read. The motion will be to acknowledge and confirm that the Town Council's confirmation of Anne Fenwick Bynum to the Board of Health at its regularly held meeting on September 14, 2009, was obtained by false pretense in that Mrs. Bynum stated that she was no longer involved in the lawsuit against the town and Board of Health, and therefore it was and is invalid. That's what we're voting on. That's the motion and the second. So we need to have a vote on that amended version. Go ahead, please.
Councilor Nicola?
Yes?
Councilor Regis?
Yes.
Councilor Spinelli?
Yes.
Councilor Vandal?
No.
Councilor Clements?
Yes.
Councilor Langevin?
Yes.
Councilor Livingood?
Yes.
6 yes, 1 no.
Okay, thank you. So this is the amended motion. Now we have to vote on the motion.
Main motion is amended.
The main motion as amended. The motion will be to acknowledge and confirm that the Town Council's confirmation to the Board of, the confirmation of Anne Fenwick Bynum to the Board of Health at its regularly held meeting on September 14th, 2009 was obtained by false pretense in that Mrs. Bynum stated she was no longer involved in the lawsuit against the town and the Board of Health, and therefore it was and is invalid. Do I have a motion?
So moved.
Second.
Okay. Any further discussion? Can I have a roll call, please?
Councilor
Madam
Regis?
Chair, am I not allowed to, are we not allowed to speak 3 minutes on an agenda item?
Go ahead,
Thank you,
Mr.
Madam Chair. Ladies and gentlemen,
Pulaski.
I remember a few years ago when there was a majority on the council that had a concern for the community's health. They were told that they couldn't rescind the vote of the council that voted for that landfill contract 5-4. So what I'd like to know, are councilors that were not on the council at the time of Mrs. Bynum's appointment, are they allowed to vote right now on the actions of the council of 2007?
No.
They aren't. It's only councilors.
Yes, we are.
What do you mean?
You're not hearing what he said.
Could you say that again, Mr.
I'm
Pulaski?
asking,
It's
if
very
councilors
late
that were
now.
not elected in 2007,
Right.
are they being allowed to vote tonight on whether or not Mrs. Bynum violated, because I noticed it seemed you're trying to get some credibility by getting these affidavits from councilors. Mr. Caprera kind of brought me down memory lane. Excuse me for my memory wandering. My father, I just left him. He's in intensive care at Harrington. My sister's there with him. Not supposed to be too many people in the room. I personally, I'm not a doctor. I do a lot of research. I think it's connected possibly to the chloramines in the water. Maybe it isn't. But his health, Mr. Clark, Mr. Morte.
Excuse
please,
me, sir. Could you get on
let me
point,
my 3
please?
minutes. I'll be
Please.
He's got 1 minute left.
Mr. Caprera brought me down memory lane. I remember Sister Rose Margaret at St. Mary's School. I believe you may have had her yourself, maybe not. She told us why we were in Vietnam, why our boys were fighting in Vietnam. We used to ask questions. Why is it wrong to kill in the scriptures, but it's all right to go over there? And we were told that in that country, those evil people allowed people to go to trial without facing their accusers. Where is Dr. O'Leary tonight? We were told that charges would be changed on people. If they couldn't get them the first time, they'd make up other charges. Respectfully, and perhaps no, you have changed. This fine attorney has been paid good money to defend some charges that were presented at 7:30, and now you're changing them at 9:30. That one didn't sound good. Now you're changing them at 10:15. Now, you don't listen to the town charter. You don't listen to the state constitution. You don't listen to the United States Constitution. But a lot of our laws are based on scripture. So I'm just going to leave you with this. St. Paul advises us not to make decisions when we're too angry, too hungry, or too tired. And I see people, in my opinion, I could be wrong, some of you are angry. No, maybe one of you are angry. Some of you are tired. And some of you may be hungry. I'm asking you not to rush into this decision. Don't do it right now. Please save the integrity of our town government. Please take your time. You're throwing things around. I know you're probably going to come to the same conclusion, but can you kindly get it all together? Have the charges correct. Have Dr. O'Leary here. Instead of having some paperwork that he filed out when he was angry about some cartoon in the newspaper, perhaps we should have, because you're not politicians tonight. You're judges. And I respectfully believe that you're hurting the integrity of our town government if you're to proceed tonight. There are other Wednesdays. You have mentioned a few times you don't like making decisions late at night. This is a night to show that it's time to take a breather, consider this, talk to your constituents, and proceed with prudence. Thank you, ladies and gentlemen.
I sit up here often, take an awful lot of abuse from all of you. And that's okay. Some of you are citizens of the community, others aren't. The ones that are the people that I'm addressing this evening. What we have here I've read. And even if I hadn't read it, I've lived it. This council voted to confirm an appointment based on some promises. I voted with prejudice, if you recall. That's not in the meeting minutes. And the reason I remember is because it's the only time in 7 years I've ever done so. Because unlike a lot of other people, I don't have trust. I don't have any trust. For good reason. Here we are. I like to see paper. I like to see it in black and white, but I was assured, so I did so. And it was ill-placed trust. There's no question how I feel about this. And in terms of Mrs. Bynum making a statement that she was told that I said that I don't like her, it's third party. Believe what you want to believe. This has nothing to do with whether I like Mrs. Bynum or not. This has got a lot to do about the integrity of the council and about somebody thumbing their nose at that integrity of the council and the respect that this council should receive, which we don't get from you. This is a quasi-judicial board, and people that are on that board should act like they're on a quasi-judicial board. And they should take into consideration that it isn't an easy thing to remove somebody from a board like that, so they should be above this sort of thing. I personally think the Board of Health should have people on it that are above reproach. No matter how tired, angry, or hungry I am, I still have my faculties. Always. This is going to go through this evening. However it turns out, it turns out. But I'm not going to wait for another day. So I have a motion and a second. We've heard all the discussions, all the arguments back and forth, and I'm now going to ask this council, who is charged by the people of this community, to do the right thing by them, to do the right thing this evening, and at least speak. For those that aren't here this evening, one person's out of state, I don't know where the other person is, but the 7 that are here need to take their oath pretty seriously and make a decision, up or down. I don't feel like I'm a judge. This is to determine whether or not our confirmation, based on the information we now have, was invalid. And I'd like to hear what the council has to say. So if you would do so, please. Roll call.
Councilor Regis?
Yes.
Councilor Spinelli?
Yes.
Councilor Vandal?
No.
Councilor Clements?
Yes.
Councilor Langevin?
Yes.
Councilor Livingood?
Yes.
Councilor Nicola?
Yes.
6 yes, 1 no.
Thank you. Okay. Now, based on that, I think that Attorney Brackett's question was reasonable. Where do you go from here? What do you do with that? It was brought before me to have this meeting and to do this, and we've done this, and I need to know what that means in terms of the future. And I'm going to ask that question of our town attorney. What is the future as a result of this vote, sir?
It would seem to me that it's fairly obvious that if she couldn't have been on at the time because she was on the lawsuit, then she wasn't on at the time of the vote and she isn't on now. It's a very peculiar case. It's not one that we encounter, thankfully. But it's not that difficult to wrap your head around. If the person couldn't be on because of not having met the condition, then they weren't on and they are not on now. And I think everyone is aware that that was the outcome of the vote, and that is the outcome of the vote.
Okay. Thank you. At this point, agenda item number 8 is the next meeting date. Counselor Clements?
I believe our next meeting date will be Monday, the 24th, at 7 p.m. here in council chambers, if it so pleases the council.
Okay. Agenda item number 9, adjournment.
So moved.
Second.
Okay. Meeting is adjourned.